All right, thank you. Ms. Gage.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender. We too do not believe that there is a conflict, but would waive any conflict if there is one.
Thank you, Ms. Gage. Court also, for its part, does not believe there's a conflict either under the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, court will consent to hear the matter. Court does call the case of the people versus, is it Choya Horton?
Yes, Your Honor.
All right.
Morning, Your Honor. An Assistant Public Defender, Natalie Pate, with and on behalf of Mr. Horton, who is present via Zoom from the MDOC.
Hey, welcome back.
Thank you.
Hi.
Hi, nice to see you.
Alan missed you. Go ahead.
I missed everyone here. Mr. Horton, could you please state your name for the court? Oh,
Troy
it looks
D.
like
Horton.
he's...
Thank you,
Troy
sir.
D.
Thank you, sir. Thank you, sir. Your Honor, I am requesting an adjournment for two reasons. One being I did discuss this with Ms. Dover. It doesn't look like either of us had the CCTV footage that's referenced in the police report. So she said she would check into getting that. And then secondarily, I have twice contacted the attorney visitor application system, and I've not yet been approved. So I'm still trying to get that squared away. So I'd ask for an adjournment like 4 to 5 weeks if possible.
4 to 5 weeks. Well, and hearing no objection from the people, probable cause conference will be adjourned to July 16th.
Thank you, Your Honor. Thank you. And Mr. Horton, I'll be seeing you as soon as I can. All right. Thank
Yes,
you,
ma'am.
sir.
Thank you. All right. Thank you, sir. All
Thank
right.
you, Your Honor.
Court calls case versus Tamika Schlip.
Morning, Your Honor. Asked Delta for the people.
Schlip.
Morning, Your Honor.
Wow.
Bright and early on your docket today.
No, go ahead.
Christina Costantino appearing with and on behalf of Tamika Schlip, who is present via Zoom from the Michigan Department of Corrections. Tamika, once you're unmuted, can you state your name for the judge?
Hi, Mr. Simpson, it's me, Tamika Schlip. Instead
Hello,
of
Miss How are you?
I'm doing okay. I got my parole, but it's on hold until I get done with this case. Then I'm going to challenge the psychiatric hospital.
Ah, okay.
Judge, on the bright side, I'm told
Oh, it's having her back.
I'm told it's her birthday today on the bright side. So, you know.
Yeah, today's my birthday. I'm 36.
Oh, you can't be that old.
I'm 36.
30. Okay. All right.
I have a son. My son's 11 and my daughter's 10. I'm an old dog.
Okay. All right.
Judge, I was just appointed to Ms. Schlip's matter last night, so I need to get discovery and need to meet with her to discuss the matter. So we would be asking for an adjournment of the PCC.
We were going to ask for the 2 weeks, please, Your Honor, since I understand this may be holding up her parole.
This may be holding. Oh, you're right.
That's my understanding. Yes, Judge.
My parole's on hold until this case is gone.
Got it.
I really want to go home.
Yes, ma'am. All right. June 25th,
When?
2026, 9 a.m. So we put it out to the 25th, Miss Slip.
Okay, at what time?
Well, I said it at 9 a.m. We'll see about that time, okay?
Okay, Mr. Simpson, I just want to let you know I've been praying for you.
Thank you, Miss Slip. Appreciate it. Happy birthday.
Thank you to me.
Judge.
Court does call the case, people versus Devin Julia Martinez.
Yes, Stephanie Cannon on behalf of.
Oh, you're back. I mean, hi.
Here.
Your Honor, we're just going to waive our right to preliminary exam. I did not know they were not going to bring her. So the paperwork as far as that. Yeah, Ms. Martinez, can I sign the waiver with your permission so we can waive over to circuit court?
Yes.
All right. And Ms. Martinez, you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Right.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Correct. I would like to also adjust my bond to being released to treatment, please.
Well, let's get the waiver done. People also waive their right.
Yes.
Preliminary examination having been waived, defendant is bound over to circuit court on count 1 in the case ending in 5840 and on counts 1 and 2 in the other matter with 3 and 4 problem.
Your Honor, as to bond, as my client has indicated, we are requesting that she be released on bond. I would ask for a very, very low monetary bond with a release to treatment. The reason for that is I do believe the cases she already has in circuit court, Judge Mood has denied bond. So in order for her to get credit for this case while she's there, a low.
Denied bond and you want me to give her bond?
Your Honor, I'm going to try to get some mitigation information the next time we are up before Judge Mood so that we can get bond in that court as well.
I was also due to address bond.
Good. Yeah.
So,
Done with your argument or?
well, Your Honor, I see the look on your face, but
Oh, what does that mean?
Ms. Martinez would like,
How I look? What does that mean?
it looks,
What? It's,
the look of understanding that you
oh, okay.
create
That's what-
now. Ms. Martinez would like the court to know that the reason why she didn't wind up in treatment the last time is because when she got there, they said some information was incorrect, therefore she could not go. And they denied her access to treatment. She wants the court to know that that information will be corrected.
Which time was that?
The last time, Your Honor.
Happened a couple times.
I understand. I understand
Okay.
that, Your
That
Honor.
has never happened before. That's never happened before. They denied
Okay.
me because it was some information.
She wants you to know that she does have a job. She has stable housing. She has a support system in the community. She's very remorseful regarding what happened. She's ready for this to be over. Her mental health has stabilized a great deal. She wants the court to know that. She wants to just get this over with some treatment. And so she's asking that you allow her to be released onto other treatment.
People's response.
Your Honor, I'm going to be objecting. This is history because she also has been contacting the victim of the domestic violence charge from in custody after being arraigned. There are 22 complete calls. So at this time, I'm going to be asking for phone privileges to revoke, given that she is calling the victim, asking, what did you do that for? Blaming him for being in jail, bringing up the assault charges, knows she's not supposed to be contacting him, so she addresses that in the calls. She also has the failure to appear. That would give me concern that she will leave treatment or not come back to treatment, and she does have that hold out of the 22nd with bond denied. There's also another hold I saw on a 14A1 with bond denied.
Yes.
And a hold out of 15th for bond second for $100 bond. So at this point, I am concerned about her attendance in court and also that she can't comply with bond conditions, given that she is violating her bond in custody at this point.
And again, Your Honor, my client understands the severity of her situation and circumstance, and she is very inclined to participate as in bond as the court would request at this point.
As to the circuit court arraignment.
Yes, Your Honor. She's been arraigned today.
Circuit court.
Oh, sorry, I got caught up in the bond thing. Yes, Your Honor. Your Honor, we will waive the reading of the, I know.
I know.
Waive the reading as to the information, Your Honor, and we would plead not guilty as to charges. I forgot we waived.
Defendant having waived formal reading, pleading not guilty, court will enter that plea. Pre-trial in these matters will be set for June 22nd, 2026, 1:30 with Judge Hamoud. In the possession case, motion for bond reduction is denied Bond will continue as set in that case. In the other matter, the motion, defendant's motion for bond reduction is denied. People's motion to restrict or revoke her phone privileges and texting is granted. Her motion to reduce the monetary amount of her bond is denied. And quite frankly, given the circumstances, I was going to revoke it, but I'll just deny it at this time because Judge Oda has a handle on it.
Can I speak to my lawyer, please?
Devin, I will try to see
You
later
available all
if possible.
All right, thank you.
What did you say? What did she say?
She said she will be down to see you as soon as she's available.
Okay.
Kind of. That's what I heard. Yes, let me get these to hand because I got, let's get a van and then. Court does call the case, People versus Rashid Abdullah.
Over for the people, Your Honor. And Assistant Public Defender, Tanaka carry out the ruling, Your Honor, on behalf of.
Oh, here.
Mr. Abdullah, state your name for the record, please.
Rashid Abdullah.
Shit, you said that last time. Your Honor, we respectfully request that this matter be set for preliminary examination.
Right. So discovery is complete.
To our knowledge, Judge, yes.
All right. People have their witnesses available on the 23rd. Preliminary examination will be set June 23rd, 2026, 9 a.m. before me. In person.
Thank you, Your Honor.
Bond will continue. Thank you.
Thank you.
Court calls case, People versus Lawrence Buckner.
And so then we have, Your Honor.
On behalf of Mr. Buckner, Your Honor, I would ask that we pass the matter. Mr. Buckner is, I just texted him, he is in the building. So you could pass it very briefly.
What's that mean?
Pardon?
What's that mean? He's in the building.
I mean, I'm understanding he's in the courthouse. But just not courtroom yet. Oh, he's taking care of some personal business at the moment. Just have a moment.
I'll pass it. Thanks. Court calls the case, People versus Leah Benton.
Good morning, Your Honor. James Fifelski on behalf of Aaliyah Benton, who is approaching. Morning. Can you state your name, please?
Benton.
Thank you.
May counsel approach briefly?
Briefly.
Thank you. Thank you, Your Honor.
Thank you.
Order. Hopefully you get that tomorrow.
Okay, Mr. Pipowski, you may, go ahead. We're good.
We're all set. Thank you, Judge.
Okay. Court recalls the case, People versus Lawrence Buckner.
Ellie says on behalf of the people, Your Honor.
Overall, on behalf of Mr. Buckner, who is approaching the podium. Mr. Buckner, when you get up here, please say your name for the record.
Good morning, Lawrence family.
Okay. And Your Honor, we are working on discovery. Ms. Senda did give me some more videos, but it's my understanding that we believe there may be some more out there. So we are asking for an adjournment at this time. The court should be in receipt of my green sheet.
I am.
Where I talked with, I got his, I'm waiting on him to check with other agencies that were involved to make sure we have everything, or if there's anything outstanding.
Okay, so the 25th would be two. You need more time than that, you think? Make sure.
20. Okay.
Probable cause conference will be adjourned to June 25th, 2026.
Thank you, Judge.
On continue. Thank you. All right. Clerk calls the cases of the people versus Robert Lassiter.
Morning, Your Honor. Raymond Cook.
Robert, on behalf of Mr. Lassiter, the case ending in 6.
Can you hear me?
And Assistant Defender Natalie Pate with an on behalf of Mr. Laster in the other two matters. Sir, we can't hear you. Could you please state your full name for the court?
My name is Robert Lassiter.
Thank you, sir.
We were trying to accomplish pleas in all three of these.
Yes, Judge.
Yes, Your Honor.
I believe the court should be in receipt of a,
But one of them was not sent to me. Because
Riverdale's case.
I don't have your case. I have a plea for.
Judge, I thought I was on a part of an email where Mr. Cook had sent it to the court. I do have it. I can send it to the court right now.
Okay, just so that you understand, he's not, where is he?
Correct.
No, he is appearing via Zoom.
All right, let's have him. Are you here during the noon block? Because I don't want to hold it up. The report doesn't even come to me, so I'm going to have to take time to get.
Oh, understood.
But I can do it one of two ways. I can either put him get the plea form to me. We can put him into a later block. Okay, if he can do that. Or what I can do is just put this out a week and take care of it then. Well, since this isn't his fault, Mr. Laster, which would you prefer?
What do you say, Your Honor?
Which would you prefer? You want me to put it out? I've got to put you either into a later block or I've got to put you out to next week.
Yes, we can come back at noon, or the court needs some paperwork that we need to get to him. So do you want to come back in a week or come back at noon?
Whatever is convenient for you, Your Honor. Whatever's convenient for you.
Mr. Laster, nobody ever cares.
Client.
I appreciate that.
Yes, sir.
Why don't later, because I've read these other ones. So if you can come back about 12:30 or so, sir.
12:30 on Zoom, Your Honor?
Yes, sir.
Yes, sir. I can sure do that. Yes, sir. It'd be
All right.
Yes, sir, I can do that.
Okay, thank you.
Oh, thank you, Your Honor.
Thank you, Mr. Laster.
You're welcome. You're welcome. 12:30 here.
Court calls case, People versus Michael Bank.
People.
Morning, Your Honor. Assistant Public Defender Davi Leba for Mr. Bank, who appears from the Oakland County Jail.
Okay, so Oakland came back. Okay. Sir, state your name.
I agree with Ms. Willenbrink.
What?
That's not Mr. Bank.
Oh. Sir, the gentleman at the Oakland County Jail, what's your name?
Jesse Iden.
Say again.
Jesse Iden.
Not on our document.
That's not on our docket. Okay, sir, what, do you know what proceeding you were supposed to be appearing for?
No, I don't know.
All right. Can we have a direct line to contact them? Because I don't know. All right. Okay, sir, just sit tight. I don't think you're on my docket. All right. But this gentleman, Mr. Bank, is on my docket.
Correct, and is at the Oakland County Jail.
So they may just have to switch out. All right, we'll figure it out. Okay, thank you, sir. Court calls case, People versus Christian Berg.
And Assistant Public Defender Nicholas Bukovich, Your Honor, on behalf of Ms. Bird. Correct. I am, Your Honor.
All right. Your name?
Christian Berg.
And Order isn't filled out. This is the
Yes,
competency hearing. Go ahead, sir.
yes, Your Honor. We're here today for a competency hearing. The defense is in receipt of a report dated May 21st, 2026, written by a Dr. Aaron Sazine that finds that my client is competent to stand trial. So we will stipulate to the findings of the reports.
Any other additional evidence from the people?
Stipulate to the report as well.
All right. Based upon that report, the court would find that the defendant is competent to stand trial, specifically that she can understand the nature and objects of the proceedings against her and can rationally assist in her defense. Therefore, the defendant is deemed competent. So, sir, what would you like to set for?
I would ask to set this for probable cause conference. It's for a brief adjournment to finalize some discussion with the prosecutor and paperwork for an offer.
Probable cause conference then will be set for June 25th, 2026, 9 a.m. Bond continued.
Your Honor.
Those ones.
Jillian, we got something to Ally.
Or was it? Oh, yes, it was that.
Yeah, he's in front.
Thank you. Good morning. Court does call the case of the people versus Benjamin Spike.
Ready to go for the people, Your Honor?
Good morning, Your Honor.
Oh, there he is. Okay.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Spike.
Mr. Spike, can you state your name, please?
Benjamin Paul Spike.
Thank you.
Your Honor, we will be requesting an adjournment for further negotiations, and we'd also like to address bond.
Okay. Probable cause conference hearing without objection to June 25th, 2026, 9 a.m. As to bond.
Your Honor, Mr. Spike originally had a personal recognizance bond in this matter. He missed his previous PCC date, the lack of transportation. His father is now actively involved in the case. His father did call our office. I called his father's name out in the courtroom. I'm not sure if he heard. There he is. I thought that might be you, but I don't think he realized I was calling him at the time. But his family is here. It's my understanding from Mr. Spike, and I think they can confirm that they will help him get to and from court. And that would address the transportation problem that he had that resulted in him missing court previously. It is my understanding that he has no prior felony convictions, and he does not have any assaultive convictions in the past.
Johnson, the people.
Jim is seeking a assault motion. I believe he pled no contest to a misdemeanor of domestic violence in 2026 already. But beyond that, we did it for discussion.
All right, thank you. How did he come into custody?
According to the notes in from the arraignment attorney, I believe he was walking down the street and was a little unusual and drew attention, and they discovered the warrant.
And he got picked up on?
I believe he's been in custody almost a week.
All right. I will grant that the previous bond is reinstated with all of its conditions.
Thank you.
I think that was a $5,000 here. Got that.
Thank you.
Thank you. Court does call the case People versus Michelle Schaffner.
Excuse me. Excuse me. Excuse me, Your Honor.
Yes, sir.
What is the bond set at, please?
I just said it. I just reinstated your previous bond before you didn't show up.
Oh,
so you had a $5,000 personal recognizance bond.
I understand. Thank you.
You're welcome.
Christina Costantino on behalf of Michelle Schaffner, who should be present via Zoom. Ms. Schaffner, can you unmute and state your name for the court?
Michelle Schaffner.
Oh, there she is.
Your Honor, this is a date and time set for PCC. We're asking for an adjournment of the PCC. There may be some outstanding discovery that the people and I have been discussing over the last couple of weeks that we want to make sure we have before moving forward.
25th of work.
It does, Judge.
During this matter, June 25th, 2026, 9 a.m. Bond continued. Thank you. Court calls the case of the people versus Michael Grimaldi.
James Fifelski standing in for attorney of record Robert Ellman on behalf of Mr. Grimaldi, who is approaching. Can you state your name, please?
I'm Michael Grimaldi.
All right. You don't have a problem with Mr. Fifelski stepping in?
No.
All right.
This will be a waiver, and I believe there's a plea offer that was finalized in circuit court.
That's correct, Your Honor. I did extend an offer to plea to an added 3 of an agreed that he wouldn't serve additional time served or sentence as one counts to 1 and 2. That is not a conditional waiver, though. Should something happen in circuit court, that offer could be.
All right. You understand that, sir?
Yes.
All right. Talk to Mr. Ellman about that too.
Yes.
All right. So, sir, you're waiving your right to a preliminary examination. You understand that that's a proceeding where the people would have to show by the standard of probable cause that the offense alleged was committed and that you committed.
Yes, Your Honor.
All right. You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
People, for the record, also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on count 1 with 2 following. Mr. Fifelski.
As to the arraignment, we will waive formal reading and stand mute as to all charges.
And in every way, formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for
June 25th at 1:30 for Judge Slay.
June 25th, 2026, 1:30 for Judge Slay. Bond will continue.
Not guilty. So far, it's not guilty.
Court calls the case.
Thank you, Your Honor.
Michael.
Your Honor, Court of Active Reflecting Commission practice pursuant to Michigan Court Rule 8.120 under the supervision of versus prosecuting attorney Ashley Bell.
Where are you from? Yeah, all right. Prison practice is granted.
Christina Costantino appearing on behalf of Michael Smith. Mr. Smith, can you please unmute and state your name for the court?
Michael Smith.
Your Honor, this is a date and time set for PCC. I have discussed with my client his right to have a preliminary examination, and that at that preliminary examination, the people must prove probable cause that he committed crimes alleged. At this time, he wishes to waive his right to a preliminary examination after our discussions and understands this matter will be bound over to the circuit court for further proceedings. I would also indicate that there have been some negotiations that have helped facilitate this waiver. I don't know if the people wish to state those on the record or not. I can state them on the record if the people wish. Thank you. Your Honor.
That to her.
I don't know. I should have just said it.
On purpose.
No.
Don't worry about it. I got you.
Sometimes they let say it. I don't want to step on anybody's toes.
Oh.
Your Honor, so pursuant to a waiver here at the district court, we have reached a resolution where Mr. Smith would be able to plead to counts 1, 3, and 4. 1, 3, and an added count 4 that would be taken under HIDA, and count 2 would be dismissed. And that would occur at the circuit court. And of course, we would need to waive the exam to facilitate that offer. Is that your understanding, Mr. Smith?
Yes.
All right. Mr. Smith, everything that your counsel indicated regarding the examination waiver is true, sir?
Yes.
Okay. You understand the nature of that proceeding and that it won't happen, right?
Definitely.
All right. People also waive their right?
Yes, Your Honor.
All right. preliminary examination having been waived, defendant's bound over to circuit court on all 3 counts.
Your Honor, he stands mute and waives a formal reading.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to those charges. Pretrial in this matter will be set
August 4th at 1:30 with Judge.
August 4th, 1:30 before Judge McNally. Bond will continue.
Thank you very much, Judge.
Yes.
Thank you.
There isn't one in the file for whatever reason. Court does call the case People versus Christian Luckett.
And is over for the people, Your Honor.
It's Michael Getty, Assistant Public Defender on behalf of Mr. Luckett, Your Honor.
Usually I'd list them. False. Your name, sir?
Chris, me or him? You or me? Christian Luckett.
All right.
Your Honor, this is the time and date set for a competency hearing. The court adjourned it for a week last time so I could further confer with Mr. Luckett and the attorney in circuit court. I have done so. We are stipulating to the report.
All right. Any additional evidence for the people, or do you stipulate also? Based upon a review of that report, the court would find that the defendant is competent to stand trial. Which specifically indicate the defendant can understand the nature and objects of the against him and can rationally defense. Therefore, he's deemed competent. I have signed the order.
Okay.
What would you?
No, I had prepared. I had one just in case.
Wow.
I didn't have one in the file.
Thank you, sir. So well prepared. All right. What would you like me to set this for?
I think if it's okay with the court, I think we'd ask for an exam.
You're ready to proceed and go forth?
Yes.
All right.
Informed of that.
So discovery is complete.
Yes.
We'll have their witnesses available the 23rd. All right. Preliminary examination will be set June 23rd, 2026, 9 a.m. before Judge Fresh Hour.
Thank you, Judge.
Bond will continue. Thank you.
Thank you, Your Honor.
Good morning. Court calls the case, People versus Peter Vasher.
Brandon Dover for the people, Your Honor.
What?
Christina Costantino on behalf of Peter Vasher, Your Honor. I unfortunately very sad to report that I don't see Mr. Vasher in the courtroom. And at this
Question, Bellinger.
I did. He didn't know where.
Okay, all right.
I would ask for a brief adjournment so I could make some attempts to locate him, but I understand and respect whatever the court rules.
Really? Okay, James warrant will issue in both matters. Bond set the amount of $10,000 cash shares.
Thank you very much, Judge.
Thank
you.
You're welcome. Court does call the case People versus Denario Boykin.
And is on behalf of Your Honor.
Good morning, I'm Robert. On behalf of Mr. Boykin. State your name for the record.
Denario Boykin. Thank you.
Judge, I met with Mr. Boykin yesterday at the jail. We went over the police report. At this time, we're asking you to set for exam.
For a preliminary examination. So discovery is complete.
To my knowledge, Your Honor.
People have their witnesses available the 23rd. Preliminary examination will be set June 23rd, 2026, 9 a.m. before
you.
Before me.
Thanks. So, Judge, may I make a brief bond motion?
Okay.
Judge, my client is the sole custody of 4 kids, 16, 14, 11, and 9. They live in an apartment. He works. He's a sole provider for the children. He's never been in trouble before in the last 20 years. The victim in this matter does not live with him, nor is she the mother of any of the children. The bond is $7,500, which my client can't post. What I'm asking this court to do is reduce it to a PR bond tether if necessary. Again, the kids are there by herself, the 16-year-old supervising the other 3. So we're asking the court to consider release to my client.
Response.
Your Honor, at this point, I would be objecting. In this case, the victim was beat to the point of her going in and out of consciousness while the sheriff deputies. When they arrived, she was attempting to climb over the balcony to escape the apartment. face, if you're not a swollen eye, blood on her face, and only remember getting her being hit or with black. Doctors believe her nose to be broken on both sides. So at this point, given the severity of this assault, I would be objecting that we bond it as said.
The only thing I'd just say is my client would agree to stay away from this. She's not related to any of the family. She will not be there.
At this point, I'm going to deny the request for a bond reduction. Bond, I think, is set appropriately. Motion to bond.
Back and see. Okay. Thank you, Your Honor.
Yes. I think we're good. Okay. I'll let Ann and you in. Court calls the case of the people versus James Lee Harris.
Good morning, Your Honor. On behalf of Mr. Harris, Attorney Nicholas North, P86482. Mr. Harris, can you please turn your camera on, unmute, state your full name for the record, sir?
James Lee Harris.
All right. Okay, what are we doing?
Your Honor, I was just assigned this case a couple of days ago, literally 2 days ago. I just received all the discovery. I haven't been able to make my way through it. I'm asking for an adjourned PCC. Unfortunately, I'm not available June 25th, so I'm asking for July 2nd.
You asked for a date? I'll let you discuss it. Other counsel that things don't go well when that happens. And I'll give it to you. July 2nd, 2026, 9 a.m. Bond continued. See, I did a nice thing.
Thanks, sir. Thank you, Your Honor.
Thank you. Sir's okay too. All right. Court calls the case. People versus, has it been Leah Winter?
That's thoughts to people.
Assistant Public Defender Nick Fukovich on behalf of Ms. Winter.
Your name?
Leah Winter.
I just for an adjournment of the comp hearing.
Yes, Your Honor, we are not in receipt of any updated report. The last report that my office is in possession of is from April, stating that that was a progress report, stating that they were working on finishing the report. I contacted the CFP on Monday, spoke to someone who worked there. They did not have an updated report in her file. I attempted to speak to the doctor who's assigned to do the report, and also he got no answer, left a voicemail. So I have no update on the status of the report, but I did reach out to CFP, and I know Ms. Felch has also indicated that her office is not in possession of any updated report either.
Correct.
All right, what I'll do is this. I'll adjourn the competency hearing to July 30th, 2026, 9 a.m. Once a report's received, if we get the report, then we can, of course, move that up, the date up and accommodate it during it.
Of course, Your Honor. Thank you so much.
Yes, Your Honor. Thank you.
Bond continue. Court calls the case, People versus Phoenix Borns.
Your Honor, Raymond Cook for the people.
Good morning, Your Honor. Christina Saxon for Phoenix Borns, who I believe is in the courtroom.
No, like you, she's not here.
Your Honor.
Borns? I'm sorry, that was so wrong. You're here in spirit. She is not here, Miss Saxon.
Yeah, Mr. Bourne relies on his mom or grandfather to bring him, and can I pass to ring them to find out where they are?
I want so much.
Would be happy.
No, I want to say no. I'll pass it. Give it a shot. That way you can't say I haven't done something nice for you.
Nice thing to do.
Thank you.
That's free, by the way. And we didn't need to say that out loud. Anyway, thank you, Ms. Saxon. I don't know why Ms. Cannon was interfering in your case.
She's my advocate.
Is she?
If it works.
Need to find somebody else. Just saying. All right, I'll pass it. and let my staff know if, what's going on, okay?
Yes.
Court calls the case, People versus Jamari Bagwell.
Ready to go for the people you're in?
What is this? Constantino Day?
I'm almost done. This is the last one. Christina Costantino, I'm appearing on behalf of Mr. Bagwell in case number ending in 0623.
Morning, Your Honor. Brian Bowling, Assistant Public Defender on behalf of Mr. Bagwell in case N13.
Yeah.
All right.
Mr. Bagwell, can you state your name for the record, please?
Bagwell. Thank you, sir. So you guys are looking for an adjournment?
Yes, Your Honor. With regards to the probable cause conferences, we are looking to adjourn for some further negotiations and to attempt to achieve a global resolution of these matters. We'd also like to address bond if the court would allow us.
Okay. Would 2 weeks be enough time for the adjournment, or did you need something?
I think we might need a little bit more time than that, Your Honor.
Okay. The second or the 9th, which?
Let's do the second.
Pending our bond motion, I may ask for an earlier date, or pending the outcome of our bond motion, I may for an earlier date, I would say.
Done.
After this one, I'm done.
The cause problems while you're here. All right. Why don't you go ahead? Okay. Go ahead with your bond argument, and then we can figure out a date.
Thank you, Your Honor. Just to remind the court, we were here last week on Mr. Bagwell's case. A bond motion was made, and the court indicated it would reconsider that today. There were some statements made about a potential probation violation. I've researched all of Mr. Bagwell's open cases. He does not have any pending probation violation or any other outstanding matters other than these 2 cases and one other that was just very recently authorized and is scheduled on your docket for next week, the 18th. We would ask that the court consider a personal bond, and I'm assuming both of these matters. He's 43 years old. Prior to his incarceration, he held down 3 different jobs. He was working at Jet's Pizza in Washtenaw. He was working at Cubby's Best and doing home health care. Should he be released from incarceration, he would have those jobs to go back to. He has, as far as I'm aware, been incarcerated for about 2 months now on these matters. He's been in, he tells me, since April 29th. Should he be released, he would reside in Ypsilanti with his significant other. So he does have local housing. He has been making the most of his time at the jail. He's in the Dawn Farms program, and he has achieved trustee status. As the court can see, his arm is in a sling. He does have a broken collarbone that he will need some medical treatment for. It's my understanding he hasn't exactly gotten the medical treatment he believes he needs at the jail for that condition. So his release could help him achieve his medical needs as well. Should he be released, he would also be attending treatment at the Hope Clinic and CMH. He would also be ensuring to go to any and all NAAA meetings. So we would ask that the court consider personal bonds in these matters. I would indicate the charges, at least on my case, the lead charge is a 2-year felony and the other charge is a misdemeanor. And again, he's been incarcerated now since April 29th, which, given my math, maybe isn't quite 2 months, but
very close.
But we're close.
No objection to that, Your Honor. I will just bring to the court's attention the matter that is set for next Thursday is 26F1-0630. That has currently a $1,000 10% bond. If the court were to grant a personal bond in the matters that are scheduled for today, I'd ask you to consider doing the same with respect to the matter that's set for Thursday.
What is that charge on that other?
On that case, Your Honor, my understanding is there's 2 counts of financial transaction device, and I can give the court the case number on that case if you wish.
Not right this second, but okay. You want the case number? Well, case number, you found it. Okay.
It's 26F1-0630FY.
That is a PD case.
That's a DB.
It's a PD case.
Oh, PD case. All right. Response?
I would just like to
remind this board that he has several open matters, and I am seeing a hold out of the environment, the 10%. On a 5,000, 10%.
Okay.
For retail products.
And if we could, Your Honor, last week that hold was also brought to the court's attention. And it was my understanding the public defender's office represented to the court that they didn't believe that anyone would pick up on that hold out of Van Buren.
Take a shot. I'll reduce his bond in these cases to $5,000 personal recognizance with the conditions that were given at arraignment, but I'll give him a PR on all of these. As part of my order, I'll also his bond to a $1,000 personal recognizance on the other case with conditions. All right.
Thank you very much, Your Honor.
Thank you.
And for the PCC, we'll take the later date, given the court's ruling. Or whatever date the court wishes. We're flexible.
She's just pushing it. She started out this morning, she was okay. Excessive case has been more and more and more.
It's my last one with you today, though.
Yeah. Oh, boy. All right. July 9th, 2026, 9 a.m.
Thank you very much, Your Honor.
Your Honor.
Oh, and also, Case, the other one?
Yeah, does it make sense?
So yes, and so we'll move that also to the 9th. So everything's together. Thank you. All right. Don't mess it up, young man. Yes, sir. I won't.
All right. I will bring it out.
Yes, ma'am. Court calls the case, People versus Taisha Morgan.
Your Honor, Raymond Cook, the people.
That was a long bond argument. It was. That took forever. That was like a games on bond argument. Where is?
Good morning, Your Honor. Christina
Okay.
Saxon
Well,
for Taisha Morgan.
Good morning.
good morning, Miss Morgan. How are you?
I'm fine, and you?
I'm doing great. Thank you. All right. What are we doing?
I'm asking for an adjournment, Your Honor. And if you recall, last time I was before you, I will be out of the country on the 18th until the 29th. So may I have a date beyond
So
that?
you need to, gotcha. Without objection, probable cause conference will be adjourned. You want the 2nd or the 9th?
The 9th, please.
Why am I being nice?
Oh, I'm
I
sorry.
don't know. No, I don't get it. I don't, something's happened to me. July
Stick with
9th,
that feeling, please.
2006, 9 a.m. All right, bond will continue. Constantino, take care. Have a great day.
Thank you.
Do you have your other client? Where'd she go?
I'm right here.
Okay, are you ready? I'm calling to you.
Thank you. You might have.
I got it. Court recalls the case, People versus Phoenix Born.
Christina Saxon for Phoenix Born.
State your name.
Phoenix Born.
Thank you. All right, you saved another one from a bench warrant. What are we doing?
Your Honor, this is my mistake. I did not get the police report over to you in time to do a plea today.
Okay, so you're looking to do a plea?
Yes, Your Honor.
But I can do it next week. Does that fit within your parameters of when you're gone or no? I can do it on the 18th.
That's the day I'm flying out.
Okay, so what did we put our last case, the 9th? We'll just adjourn it out to the 9th of July.
Okay, thank you.
All right, bond will continue. Thank you.
Thank you, Your Honor.
See, what's in that thing? Okay, never mind. Court calls the case, People versus David Yargi.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. Roger, on behalf of Mr. Yargi.
Sir, please keep looking forward. State your name. David Yard.
Judge, I met with Mr. Yargi yesterday. We went over the police report. He's asking that we set and examine this matter.
All right, so discovery is complete. People have their witnesses available the 23rd.
There may be some additional discovery that might be needed specifically for this case. In my review, the detective got a phone recording of some CCTV footage, native CCTV footage. I reached out to that detective to see if they could get that. They said they don't know if it exists anymore, given it may not have been preserved. And I think there may also be some body cam from some of the officers that was not sent over to our office yet. I discussed that with Mr. Kilwell to let him know that may exist, but I don't have it yet. He said that he was fine with moving forward to exam. If he's willing to make that representation, knows that there won't be an adjournment for that discovery, I would have no objection to setting it, but I want to make sure that record.
Judge, I'm in receipt of some video. Just speaking with Mr. Yargi, he's not demanding, but he's insisting that we hold an exam as soon as possible.
So you understand that if that discovery may become relevant, I would not be granting an adjournment because you don't have it, because you now know it exists, but you're asking me to set it. You understand that? Yes. All right. People have their witnesses and available the 23rd?
Your best, Your Honor.
All right, preliminary examination will be set 23rd, June 23rd, 2026, 9 a.m. That's before me.
Thank you.
And we'll continue.
Come and see, okay?
Oh, need on that. Well, just to the side, just. Footage. Court calls case, People versus Kenyatta Johnson.
Your Honor, Raymond Cook for the people.
Good morning. Christina Saxon for Kenyatta Johnson.
Oh, she's here. Yes, she is. She's here. Ma'am, can you state your name?
Kenyatta Johnson.
Thank you. All right, what are we doing this day?
Your Honor, as you know, this was a kind of a companion case with Scheffner. So I am asking for an adjournment, but I cannot do it on the 25th. So can I have it on the 9th?
Yes, ma'am. Any objection from the people?
No, Your Honor.
Probable cause conference, July 9th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case, People versus DeJure Bond Sanders.
Alexander, on behalf of the people, Your Honor.
Good morning, Your Honor. Ashley Hannibal for Mr. Bond Sanders requesting permission to practice pursuant to Michigan Court Rule 8.120.
Leave her alone. What?
Okay.
You're doing just fine.
No, that was useful. I didn't know for adjourning today. That's not why I had.
You know what?
We'd like to request an adjournment.
That's not your fault. You know whose fault it is?
No.
All right. Permission to practices.
All right. Thank you.
Go ahead. Did you state your appearance?
I did, Your Honor.
Okay.
I would have more.
You want more? Got it.
Judging why we're adjourning today.
Pardon?
Judging is why we're adjourned today.
Gotcha. Okay. What are the bond issues?
Your Honor, it came to my attention that Mr. Bond Sanders has been contacting the victims since he's been over in there. 39 calls from his PIN to run over. So this time I'm going to be asking that his phone and text privileges be revoked. I did also want to note for the court that I've received media from the other agencies that assisted on this case yesterday, and that could potentially be leading to more charges, including resisting, obstructing, and potentially felony firearm. Jostling is part of the reason for the adjournment as well.
All right. You have any response to that? No.
I don't.
Okay.
step in on that one, Your Honor.
That's fine.
Thank you. Your Honor, I did talk to my client yesterday. He indicated to me when he was arrested, he was under the influence of alcohol. He was arraigned and he kept telling them, he's like, I don't understand what's happening. I don't understand what's happening. It's my understanding that so when they took him up, he was telling them, he's like, I'm not right. But they arraigned him anyway. Okay. And I explained to him that at that point, the court would have told you that you can't have contact with the complaining witness in this case. And he said, I don't recall that. I don't remember anyone telling me I can't have contact. Again, Your Honor, he was highly inebriated at the time of this, according to my client. And also he thought that the person they were indicating, he's like, at the end of this, based on the conversations he had, he thought the complaining witness was his cousin. And so he didn't know that that he couldn't be in contact with at least two of the individuals that they're saying he was having contact with. And I don't know that the court order actually said he couldn't have contact with the child.
Your Honor, I will note one of the calls, he does mention his no contact list of the people he's not allowed to contact. And in that, he mentions the victim's mom, and the kids.
So he actually says it.
In the call.
Really?
And this process has been before this court before on.
I was going to say that, but he specifically listed out those things.
Called to the victim, defendant mentions who he has on his no contact list. His no contact list consists of the victim, the victim's mother, the kids, and some other people he claims not to know.
And then after that, he makes contact. Oh, okay. So despite being highly inebriated, not understanding what the magistrate was saying, seems knew enough to communicate it to other people.
No, I didn't.
Wow.
My client is
So your client and what you represented to the court, and I'm not blaming counsel because you only go based on what he says, also represented something that appears to be a falsehood.
Your Honor, my client is still, he's denying that happened. I don't have those phone calls.
Denying the phone call happened?
He's denying that he said that he knew who he couldn't contact.
Thought it was Kenya Davis, was the only person that I knew of. I didn't know about anybody else that was on my case. Like I told them I was under the influence. I had been drinking like 3, 4 fifths that day. I didn't know that my victim on my case was my case. I mean, I'm just saying though, y'all not giving me the option to talk. I have the right to talk, right or wrong, you know?
Go ahead.
I didn't know what.
You know what? You got counsel, but if you want to take a shot, take a shot. You can talk to me.
Your Honor,
talk to anybody.
We're asking that those calls be turned over to our office for review with the client. And we are denying the accusations.
At this time?
Yes.
Understood. All right. And I'm sure those calls will get over to them today. All right. Anything else regarding this?
Your Honor, we are also requesting the 911 tape in this matter, which
On the top. So normally they'll get those on by Friday or Monday.
Probable cause conference will be adjourned to June 25th, 2026, 9 a.m. Bond at this time, given the people's motion, his bond is revoked. It's also his phone and texting privileges are hereby revoked also. Thank you.
Thank you, Your Honor.
So, court calls case, People versus Laura and Dia. Where is she? Really? Guess we'll wait. I know you're going to come up here and start talking just to fill time. Just gets up here.
Joy game.
No, don't hurry, Your Highness. It's okay.
Send it, they told us.
Good morning, Your Honor. I've been public defender tonight.
I'm not mad at you. Your name, ma'am?
Laura and Dia.
Thank you.
Now, Judge, I was sitting here all morning.
Oh, so it's our fault? That's your excuse?
I mean,
I was
looks like
all morning.
I walked out.
Oh. Okay.
Your Honor, Miss Andia, she was in custody. We've spoken a number of times. We were just out in the hallway speaking now. I think that one adjournment and we'll know exactly what we want to do on the next hearing. If the court is willing to give us a week, I think that's more than enough time for us. It's just a conversation. It ain't gonna happen.
Any objection to an adjournment? June 25th, 2026.
Thank you, Judge.
Thank you.
I'll give you a penny. Easy stuff. I'll come talk to you.
Court does call the case. People versus Sean Charnley.
Ready to go. Well, Your Honor.
Just so, because, hang on, because you're at Maryland, don't talk to him. Okay, I'm just protecting you. All right. Sir.
Senior assistant.
Your name, sir?
Sean Charnley.
Thank you.
Yeah, I do have your green sheet. We are requesting an adjournment. There's some additional discovery that I requested of Ms. Dover. In addition, Mr. Charnley and I need an opportunity to speak.
Okay. Couple weeks will be.
That would be
okay.
That works.
Adjourn these to June 25th, 2026, 9 a.m. Bond will continue. Thank you, Charnley. Court calls case. People versus Tony Bailey.
Your Honor, Raymond Cook for the people.
There she goes. She's talking to me. Waste.
Joy Gaines, Senior Assistant Public Defender with and on behalf of Mr. Bailey. And
sir.
Tony Bailey. Thank you, sir. How you doing?
I'm doing great. Yourself?
Hey, good seeing you.
I don't get that much. Thank you.
I know.
Your Honor, I apologize. I left the green sheet over there and I will make sure you get it. We are asking for an adjournment. We had some difficulty trying to reach Mr. Bailey. He and I have an appointment set up for Wednesday for him to come to the office. So I think that will resolve our communication challenges.
Without objection, probable cause conference July 2nd, 2026, 9 a.m. Bond continues.
Right. Thank you.
All right. Thank you. Take stuff.
See you later.
All right. Speak. All right.
Oh, no.
Court calls the case. People versus Anthony Turner.
Your Honor, Raymond Cook for the people. I believe this is Mr. Drooks' case. I did have an email with him this morning. I'm not sure, but he might think he's in the 12:30 block because he said he'll see me at 12:30 today.
He is on Zoom. Mr. Drew.
My apologies, Your Honor. Yep.
All right, we're here on Mr. Turner's case.
That's correct. I am in receipt of the report for May 22nd.
All right, and how would you like to proceed on this?
Your Honor, we would
You have
stipulate to the findings.
No other additional evidence?
No, Your Honor.
None from the people need to stipulate to the report.
All right. Court would find that at this time the defendant is not competent to stand trial but restorable. So the court will enter that order. I'll set a comp review date for September 10th, 2026, 9 a.m. Bond will continue. And Mr. Drukas, I'll need an order reflecting
Yep,
that.
I'll provide that one over to the court here shortly.
All right, thank you. Thank you, sir.
Thank you.
Court calls case People versus Garcia Bravo.
Brandon Dover for the people.
Assistant Public Defender Davy Lieb on behalf of Jacqueline Bravo Garcia.
Yeah, I'm here.
Gotcha. And this is, I said her name, the name wrong, but, all right, I need a camera.
Yes, Your Honor. Give me one. Oh, I don't know what's
And
going on. Oh, there.
Say your name, please.
Jacqueline Baba Garcia.
All right, thank you.
Andrew, I'm requesting an adjournment today. We're currently working on reaching a resolution.
Hearing no objection, I'll adjourn this matter to, we have an adjournment. Adjourn the matter to July 2nd, 2026, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor. Have a good day.
You do the same. Court calls the case, People versus Justin Heaton.
Ready to go. Double take, Your Honor.
Michael again, Assistant Public Defender. Well, approaching.
Yes, you may. Sir, can you please state your name?
Justin Heaton.
Thank you.
Mr. Jones, make it to the podium.
Again, before we move forward. All right, thank you.
Thank you, Judge.
For the passion. Court calls the case, People versus Jason Brooks.
Ready to go for the people, Your Honor.
Assistant Public Defender Zach Vinny with on behalf of Mr. Brooks, who was until recently on Zoom. He just texted me that he just got kicked out. Mr. Brooks, are you there?
Yeah.
Don't. Really? So what he's telling me is true?
No.
All right, go ahead.
Your Honor, we were planning to set for exam, but I would ask to briefly pass so I could see if I could get back in.
Why not? I'll pass it, see if we can get him back. Yeah. Court calls the case, People versus James Jones. Oh. Yeah, no. Oh, there was it.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Jones, who is now approaching, or will be approaching. Mr. Jones, make it to the podium. Can you please state your name for the record?
James Jones. Thank you.
Thank you, Your Honor. At this time, I'll be requesting to set this matter for preliminary exam. To my knowledge, all the discovery is complete.
We'll have their witnesses available the 23rd.
Yes, Your Honor.
Preliminary examination, June 23rd, 2025, 9 a.m. before Judge Fresh Hour. Bond Wilkin.
One of the other judges in the county.
Thank you. Court calls case, People versus Michael Brown.
Assistant Public Defender Davi Lebo for Mr. Brown. Brent, would you tell the judge your name, please?
Michael Brown. Thank you.
Andrew, we're going to be requesting an adjournment. We've requested a substance evaluation for mitigation purposes, and my understanding that's been completed, and I'm just waiting to receive results.
No objection. Probable cause conference will be adjourned to July 9th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you. Court calls case, People versus Christopher Kelly.
Ready to go.
Yeah.
Good morning, Your Honor. Ashley Hannibal for Mr. Kelly.
Your name?
Christopher Kelly.
All right. What are we doing?
We'd like to set a preliminary exam.
Discovery is complete.
Yes.
People have their witnesses available the 23rd. Preliminary examination will be set June 23rd, 2026, 9 a.m. before me.
Your Honor.
Fine, continue. Thank you. Court calls the case of People versus Ashley Brick.
And Assistant Public Defender Nicholas Barkovich from Miss Ashley Brick, who is appearing via Zoom.
There she is.
Good morning.
State your name.
Ashley
Good
Burke.
morning. Thank you.
At this time, Your Honor, I was requesting a brief adjournment to get some information over to the people for the purposes of negotiation.
Probable cause conference will be adjourned July 2nd, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you.
You're welcome. But standing up there with threatening pose, I feel unsafe. Court calls the case People versus Merrick Lincecum.
Read it over for the evening, Your Honor.
Oh, okay. Kenny, you can't be calling the prisoners out.
What?
Don't bring them out when they.
I did.
Why are you waving them in?
I did what? No,
That's how
McBride,
he-
I was saying.
Sitting down. No, he was talking to my staff. You were just interfering. Yeah, and now he's upset.
Your Honor, this case has actually been resolved. We do have a plea in this matter. However, we're going to do a new no contest plea. So I need to get the paperwork to the court. So if I could have a 1 week for that no contest plea, we would greatly appreciate it. Hey,
Hey, you know how to act by next.
yes.
Okay. Probable cause conference, June 18, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
What's happening?
We're calling the case People versus Lamar Butler.
That's for the people.
Public Defender Zach Vineyard, on behalf of, but I do not believe with Mr. Butler. Your Honor, Mr. Butler is homeless, does not have any phone or email. We have no way of contacting him. I believe he also has court today in 15th District Court, so I hope he's there. We would ask for an adjournment.
The bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $25,000 cash surety.
Understood, Your Honor.
Warrant will issue immediately. Court calls the case of the People versus Giovanni Pryor.
Yeah, listen, I'll be happy. Your Honor.
Ashley Hannibal on behalf of Mr. Pryor.
Your name?
Giovanni Pryor.
We doing?
We'd like to set a preliminary examination.
All right. Discovery is complete.
Yes.
People have their witnesses available the 23rd.
That's your phone.
Preliminary examination will be set. Have you ever heard of that? Like now?
Her hands are full of the
No one wasn't. She's
preliminary examination.
Why are you handing out? What? This is. Excuse us a moment. Really?
What else?
Preliminary examination, June 23rd, 2026, 9 a.m. before. You want to pick a judge or no? Okay, before Judge Fresh Hour. I didn't know how far she was going. Bond will continue. All right, sir. Thank you.
Can I speak to my lawyer right quick before?
For what, you don't want it set, sir? Hold on. Did you not want it? Can't do that. Do you not want me to set it for preliminary examination?
I'm not even sure what's going on right now because I.
Gotcha.
Everything.
That's fair. That's fair.
So I'd like to speak to my lawyer.
Lawyer, before we go ahead with something to say. Okay,
Well, I could get-
that's what I wanted to know. No,
I
it's fine.
don't know what's going on.
So what I will do is we'll keep the file. I'll pass it, give you a chance to talk to him back there, and we'll bring you back up. Fair enough?
Yes.
All right, thank you.
All right. Thank you, Your Honor.
See, that wouldn't have happened. First of all, Cannon weren't involved, but then Ann, if she hadn't interfered. Yes, you. Court calls the case, people versus, is it Stevie Kanga or Stevie Kanga?
Ready to go over for the future.
Morning, Guy. Noah Gago seeking permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of First Assistant Public Defender Procio Feaster on behalf of the defendant.
Hello, Mr. Feaster. Why are you so nervous when you come up?
I don't try to.
Oh, it's like, what?
I don't know what to tell you, Your Honor.
He's like, she like steps up to the podium and everybody gets tense in the room. It's like, the rest of the practice is granted. You need to have him relax.
I'm working on Judge. All right.
You have a client?
He's supposed to be appearing over Zoom, Your Honor.
You don't have to check in. Unless these are dying.
Kanga? Not here.
Yes,
Your Honor.
Oh, hold on.
Yes, Your Honor.
What's your name?
Stevie Kanga.
Got it. Okay, he's there. Stop sweating. Good. What are we doing?
We're requesting an adjournment for ongoing plea negotiations, Your Honor.
Hearing no objection. Will cause conference, July 2nd, 2026, 9 a.m. All right.
Thank you.
Bond continued. Thank you.
Thank you, Your Honor.
Oh, you didn't even give the man, relax. Calm down. Jeez, oh, please. It's stressing me out. You don't know what happens when that happens. Not gonna be his fault. What are you doing down there? What is Ann doing? Court calls the case, people versus Tasha Shiner. Oh, boy.
Give up and go home.
Went south.
An Assistant Public Defender, Jay Bellinger, on behalf of Ms. Shiner, who appears.
Hello, Ms. Shiner.
Ms. Shiner, can you please?
Tasha Shiner.
Thank you. That's why you were trying to intimidate her, because she was on the other side.
I didn't even know that you were covering this case.
We're trying, oh.
That's what it was.
Oh, I saw what you were doing. All right.
Your Honor, at this point, I am to address, I do need another PCC, but I would like to address bond in this matter. I have reached out to Kristen Sample of the 22nd Recovery Court. We have been informed that she's probably not going to be able to be reviewed until July 2nd. That puts us about a month out. We have actively been working on her holds. And she did just get one taken care of, thankfully. She still has, I believe, 2 holds out of Wayne County, which we're actively helping her with as well. We are asking for reconsideration for her release to inpatient treatment when a bed becomes available, merely for those reasons. I just don't necessarily see a point, and I don't want her just sitting in the jail for an extra month waiting to be evaluated when she'll eventually have to go to treatment regardless.
You mean if she's accepted?
Correct.
Really, anyway.
Either way.
Gotcha. Okay. Response.
Respect. She had a
I think so.
February 19th of 26, that was a bond violation. She also failed to appear on January 22nd of 26. She does seem like but risk letter out, we do not believe that she will come back. And as such, Wayne County Jail. And on this case, he was definitely on control, and she had stolen credit cards and was using them at market and as a benefit. So at this time, we deny.
And Your Honor, respectfully, Ms. Shiner knows what she has to lose here. She knows that she's been referred to recovery court. She knows that if she were to bail on inpatient recovery, they're not going to evaluate her to the extent that they won't already know at the time of their meeting that she'd already bailed on inpatient treatment should she do that. I think a GPS tether would be sufficient, and knowing her whereabouts, I just think.
Let me stop for a second. Are there other holds on her?
I believe that she does have a couple of other holds, Your Honor, that we are still active.
Where?
I thought that they were in Wayne County, Your Honor. She's advising me. What's that?
I just got it there. I already got that taken care of. When I get out of here, I start information.
She advises that she's already taken care of those. So those holds may not actually exist at this point. She did just take care of the Alcona hold, I believe, yesterday. So, I mean, I don't think anything is holding her at this point.
Took care of one yesterday?
Yes.
I thought they were indicating that there were holds on her.
There had been.
Right. And the problem is that go ahead.
She does have 3 holds, one out of Westland, one out of Van Buren, one
Out of
Right, take care of it.
which one?
Westland and Van Buren.
I actually heard you the first time. I just wanted to hear what the
And that is the hold we took care of yesterday, Your Honor. Alcona.
Took care of Alcona. What about
Alcona?
What about the other holds?
Out of Van Buren. I mean, Your Honor, again, our office is actively working with her to handle those holds, and we will continue to do so.
Right, I get that, but my problem with me, if I were inclined to release, she's got these other holds.
Certainly.
And I could say, go to treatment, but then that doesn't happen because of that. And then it creates more problems because then no assessment's done. And then getting her to sobriety court, which I think she needs, gets hampered. I mean, it's not anybody's fault. I'm just saying that's what worries me. Tell you what I will do. At this juncture, I'm going to deny your request to change your bond. So I'll deny that again. I will adjourn these out. They can't see her till the 2nd?
Your Honor, I'm told that there are a number of people ahead of her.
A number of people ahead of her in custody?
I wasn't given that information as to whether they're in custody or out of custody. I was just told there were a number of people ahead of her in the line for recovery court to be evaluated. So,
right, but I thought they put some preference on those in custody.
I believe that they do.
So can we do this? I'll put it out to that same date of July 2nd, since it's a date, and let's see if we can do that. And maybe ask them if they know that she's in custody.
Oh, they do. They're aware. They do.
Okay. All right. So I'll do that, and I'll put these all out to July 2nd and do it that way.
Okay. And I just for the record, Your Honor, I imagine that if we get confirmation that the holds are all cleared, I might be able to get a stip in order with regard to the prosecutor and put that in front of the.
I don't know if they'll stip it, but I would indicate that I would be, if she gets all of the matters, the other holds cleared, the court very strongly is inclined to grant a release to treatment on a PR with a GPS tether. All right. So, and I guess, Mr. Bellinger, I'm not saying that people have to agree to that. That's the court's inclination. If they don't, then of course I would invite a motion at an earlier time for me to address it.
Certainly. Thank you very much.
All right. Thank you.
We'll continue to.
Court calls case Michael Bank. Call. Oh, there. He's unmuted.
Assistant Plug Center Davi Lebo for Mr. Bank.
Now I know how you guys knew it wasn't him. Anyway, go ahead. Just say it.
I believe we're waiting for him to state his name, Your Honor.
Pardon?
I believe we're waiting for him to state his name, Your Honor.
He's not unmuted.
Well, we are setting the matter for preliminary.
Okay, but I know. Mr. Banks, there you are. Mr. Banks, can you state your name now?
Michael Bank.
Thank you. And discovery is complete?
It is, Your Honor.
And people would have their witnesses available the 23rd?
Sir, I am not available that day. Sleep, so after that day.
Okay.
I think 13 felony counts. So.
Oh, okay, so that's correct. So there's no objection, there's not going to be out anytime soon.
I would agree with that, Your Honor. So we would not object to a later date.
July 7th, will that work? I'll set preliminary examination July 7th, 2029 AM before Judge. Okay, so that'd be a no. All right, let's start again. That's not asking for a date. Got it?
I didn't say specific.
No, you're right, you didn't. That's what makes her a good lawyer. She's right around that. We'll set preliminary examination July 14th, 2026, 9 AM before Judge Washington.
Well, thank you, Your Honor.
Court calls case people versus Jonathan Carey.
Y'all good? You done?
Jonathan Carey, probably asked, sorry.
State your name. Go ahead.
Jonathan Carey.
Thank you. Even the paper is tense.
That's not possible.
You're asking for an adjournment.
We are, Your Honor. We're still waiting on some discovery that was mentioned in the police report.
Okay. Folks have any knowledge of that or?
I'm a Hanover Police Department. I am not heard back from them.
Got it. Okay. Probable cause conference. Let's adjourn it to July 2nd. Is that right? Yes, July 2nd, 2026, 9 AM. Bond continue. All right. Thank you, sir. That's that one. Thank you. Court calls case people versus Terrence Smith. Your name? Terrence Smith. All right. Just a moment, somebody will be with us. Oh, it's Joy Gaines. We'll wait for Joy.
I'm so sorry.
No, it's okay, Miss.
Trying to do too many things at once. Joy Gaines, Senior Assistant Public Defender, representing Mr. Smith. Your Honor, we have come to a resolution in this matter.
Okay.
It is my understanding that the people are offering that upon a waiver to circuit court, that they would be agreeable to a sentence agreement of no upfront jail time as well as to HIDA. So you need to sign it.
All right, so he's waiving his right to a preliminary examination.
That is correct. And Your Honor, we would also like to address bond.
You understand there's a conditional bond violation.
Your Honor, it is my understanding that there was a conditional bond violation. I did ask, and it was my understanding that that was in the misdemeanor matters. In terms of the no contact with the complainant in those matters. This matter is a R&O. Mr. Smith has learned a great deal since.
Before I even go into that.
Okay.
As to the waiver, sir, you're waiving your right to a preliminary examination.
Yes, sir.
You understand that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. As to the arraignment on that, you waive formal reading, stand mute. All right.
Yes, Your Honor, all those things.
And then having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
23rd at 1:30 with Judge Hunky.
June 23rd, 1:30 for Judge County. As to bond.
Let's talk about that right now. Your Honor, and in terms of the bond, Mr. Smith has indicated that he's learned a great deal since he was with me on this matter the last time we were in court. At that time when we were here, he was unemployed. He had not been working at all. He has since that time obtained employment at Kentucky Fried Chicken. In addition, indicates that he had
At Popeyes?
not Popeyes.
Just asking. Go ahead.
Popeyes, but he's open to applying.
No, I'm not. I'm just soliciting employment for anybody.
Okay.
Go ahead.
He also indicates that prior to that time, he had been drinking and he had been using marijuana. He has not consumed any alcohol or marijuana since that time. He is really trying to make change his life. We are asking the court reinstate his bond in this matter, which was a personal recognizance fund. He does have strong family support. His mother communicates with our office fairly regularly, and he relies on her a lot for advice. And it is my understanding that domestic is no longer pending.
Well, here's your response from the people.
I just want to make sure that I'm understanding you clearly. The last violation report that I had is from June 2nd. Is that the last violation report has also?
Yes.
Yes, where he was arraigned and his bond was denied.
Yes. If that's the last violation, as I indicated to Ms. Gates, I'm going to leave this to the court's discretion. I believe you've been in over a week at this point for that violation. And I do recognize that the underlying domestic violence was absolutely confident.
Okay, but here's on April 30th, he was before me. And he admitted to the violation, the previous violation. I took that, sentenced him to 18 days, credit for the 18 days he served, and let him out.
And
Hold on.
okay, I apologize.
I do that. I reinstated his PR bond and did that. And then within very short order, he's back. And so I get what you're saying, but I don't mind taking a chance on someone, but I already did that.
So, and I may be confused, but I thought that on that day that we were having the hearing on that we had the domestic front as well as this one, I did not.
I'm just looking at my order on this case, and my order on this case on the 30th, on April 30th, I released him, gave him 18 days, and I said he needed tether, location tracking tether prior to release. I release him, and then the only thing I can say is in very short order, he's back.
Okay.
Now he's standing, I mean.
I understand. I did think since we had both cases for you that those orders with regard to the complainant in the domestic were on that case. So with that, in addition to the things that my client has learned, He would also like Your Honor to know that he apologizes for that contact. He was in a desperate situation. As we've stated, he had just recently obtained employment at Kentucky Fried Chicken. His mother works and has been working recently overtime, and he was desperate to get a ride to work. And
Here's the problem.
knows it's wrong.
I know he knows. The problem is,
but he also
he did the other thing. At that date, I didn't have to release him on that date, and I did. And then he does something and ends right back up before. I mean, I can't keep doing it.
Mr. Smith would like to say something.
Go ahead.
I'm sorry, Your Honor. I was just before a ride in need. I take full accountability for my actions. I understand that you've been giving me grace and giving me mercy and leniency, and I appreciate you for that. But I'm trying to change my ways, and I really am, and I hope you can really see that. I just got a job, and I really haven't been working, and I just don't want to lose this job, and I'm not trying to make excuses. And me and my girlfriend, we're on good terms. Both of my cases got dropped. I'm just trying to change, sir. And I understand that I messed up the first time. I'm just asking for one more chance.
Well, you messed up twice.
I'm just asking.
You messed up the first time. We got to a point and let you out, reinstated everything for you because you told me the same thing. You knew what your conditions were and that you would follow them.
Yes, sir.
And then the problem, so I let you out on that promise.
Yes, sir. I'm telling you.
And you messed it up. And I can't keep doing it, and I'm not going to do it. I don't mind showing grace to somebody. I don't mind giving them a chance. But when giving a person a chance, you got to take it. And you got to just, I don't think you're a bad person, but you got to do the right thing.
I'm sorry, Your Honor. Really am. I just got a job last week. I've been only was working for like 2 weeks.
Young man, I get it, but I can't. Can't do it. Motion for bond reduction denied. Bond will continue. All right. Certainly, you can raise it before Judge Tucky, and maybe she'll feel differently. All right. Thank you.
And our next court date is June 26th. Is that correct?
Sure.
June 23rd. Thank you.
June 23rd. Courthouse case, People versus Mario Crawford.
Stephanie Can on behalf of Mr. Crawford.
Your name, sir?
Crawford, Your Honor.
Thank you, sir.
Your Honor, I believe you have a green sheet in it.
Of course I do.
Yes, but our Mr. Crawford is residentially, challenged. And so our office has a little bit of difficult time meeting with him. We are going to meet Tuesday because we want to talk about sobriety court in his case. So we're going to meet Tuesday. So we just need a little bit of time on this case, Your Honor. He has filled out the paperwork. I am going to.
For sobriety court?
Yes.
Okay.
Just to get the referral started while we go over what it means.
Will July 2nd work for you?
Your Honor, July 2nd will work. Yes.
I didn't really care what you said. Will it work for him?
Yes, sure.
Well, thank you. I'll adjourn to July 2nd, 2026, 90.
Thank you.
Bond continued. Thank you, sir.
Thank you. 1 second.
Court calls the case, People versus Jason Shemansky.
Your Honor, Raymond Cook for the people.
This is a tag, but it's okay. Thank you. Your name, sir?
Jason Alexander Szymanski.
Thank you.
Jordan Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Szymanski. And Your Honor, I thought I did a green sheet for him because we are requesting an adjournment.
All right.
Mr.
Your green sheet's missing?
My green sheet is missing. I think,
No.
no, I think it's probably me.
All right.
I think it's probably me. Mr.
How much time did you need?
We're asking for 4 weeks in order to prepare mitigation.
Got it. Any objection from the people?
No, Your Honor.
July 9th. 2026, 9 a.m.
Yes, sir.
Done.
Great. And I will make sure to get that to you.
Court calls the case of people versus Mohammed Dari.
Brandon Cook for the people.
Brian Bowling, the other Mr. Dari, Your Honor. Who was approaching? Can you state your name for the record, please?
Mohammed Dari. How you doing?
We discussed the judge. It'll be correct.
Guess what?
His shorts.
Oh, you mean like wearing the whole pant?
Yeah, the whole pants.
I'm sorry.
He didn't know.
Oh, but there's like, it's hot out there.
It is very hot. And
Hot.
they are pretty
That
long.
is no excuse. There's air in this building somewhere, but not in this.
Yeah, I don't think it's working today.
All right, I'll let it go.
Thanks, Judge.
I have before me a plea form. Is that what we're doing?
That's what we're doing, Judge, yes.
Defendant's going to be pleading to an added count to a retail fraud second degree, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. There is an agreement that the prosecutor will recommend prosecutors for that supports full understanding of the agreement.
That's correct, Your Honor.
That's my full understanding as well. Is yours?
Yes.
All right. May I have him sworn? Shorts and all. No, go ahead.
Salary swear to the testimony about the guilty. Also, nothing but the true self.
Yes, sir. Mohammed Ali.
All right. Sir, it is this court's understanding you're going to plead guilty to the charge of retail fraud in the second degree. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court cost. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that becomes the maximum fine. You understand that?
Yes.
And understanding all of that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
All right. You signed an advice of rights form. Is that correct?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5 of that form. Those are your rights, which are part of a trial.
Okay.
And by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yeah.
You understand you're giving up your right to appeal of rights.
Yes.
Are you on probation or parole? Has anybody promised you anything other than what's been stated here today to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you are indeed guilty of this offense? On October 2nd, 2025, at the location of 3825 Carpenter Road, Pittsfield Township, Washington County, State of Michigan, what did you do at the Meyer that makes you think that you're guilty?
I walked out, was walking out with something I didn't pay for.
All right, you went in and what you were walking out with was?
It was some Pokemon cards.
Okay. And these were offered for sale by Meyer?
Yes.
All right, you didn't have anybody's permission to take that property, did you?
No.
All right. And the store was open to the public at the time?
Yes.
All right. And are we doing this on value? All right. Was the total value of the cards that you took, was that in excess of $200?
Just of 200, yeah.
Okay. Sir, I do have to advise you that if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, the court would no longer be bound by any sentence evaluation or recommendation. You understand that?
Yes.
And you would not be entitled to withdraw your plea.
Yes.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
I'm aware of none, Your Honor.
And have I complied with the court?
Yes, Your Honor.
You have.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be July 8, 2026, 9 a.m. before me.
Thank you.
Thank you very much.
I just stopped.
Bond will continue.
Stop there.
Or what I'm going to suggest that you do on your way out is left-hand side is my probation department. Stop in there and talk to them.
Yeah. Well,
Okay.
thank you.
They won't say anything about you having shorts on.
Thank you.
You're welcome. Court calls the case, People versus Antoine Taylor. But it is.
Assistant Public Defender Donnie Lieb on behalf of Mr. Taylor.
Your name, sir?
Antoine Taylor.
Thank you.
And we're going to be requesting adjournment. I'd like to have some more time to discuss the matter with Mr. Taylor.
Any response from people?
No objection. That purpose strong.
Probable cause conference will be adjourned June 25th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case, People versus Amber Dunson. See, he needs to learn something. She's happy whenever I call her. You what? You don't know what to say? You're gonna talk to him? You have joy like that.
So, Your Honor, well, Assistant Public Defender Natalie Pate, but on behalf of Ms. Dunson, Your Honor, I do have an explanation for her failure to appear. I believe her mother just called our office this morning saying that she's in custody at the Oakland County Jail. That's the only information I have. I have no idea for what or for how long, but that would be the explanation for her failure to appear and would explain why we're able to have contact with her on Monday, but when I was trying to reach her yesterday, that did not go so well for me. So I would ask for adjournment.
Okay, and we also call the clerk's office who worried. And she's
Oakland.
County Jail.
All right. What do you want me to do, Happy? No, I'm just
Adjourn the matter will be at least 2 weeks from it.
That came from her? No, you're okay. You're okay. I realized you were just saying something, but Feltes actually said that though? Because usually, look at Feltes, she goes, Ben's warrant. That's what I was expecting, but no, I guess not. I don't know what to do. I'm confused. I'll adjourn it. I'll adjourn it out. Why don't we just make it July 2nd?
Sounds great.
26, 9 a.m.
Thank you.
Court calls the case, People versus Kyle Zimmerman.
That's the goals. People.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Zimmerman, who you approach the judge. Come on.
Your name, sir?
Kyle Zimmerman.
Thank you.
Your Honor, we'd ask the court to set this matter for preliminary examination.
Discovery is complete.
Yes, to the best of my knowledge, Judge, we have reviewed a lot of it. I mean,
People have their witnesses available the 23rd.
We'll track that date, Your Honor. I'll also make a record at this time. I did tell Mr. Gaddy that I do believe a charge of bank robbery is likely to be added in addition to the current charges of armed robbery, felony firearm, felonious assault, and felon in possession of a firearm.
that is correct, Your Honor. It was my understanding it might be coming today. But yeah, she did advise me that it would be added regardless. And when I said we've reviewed a lot of the discovery, there's been a lot to review and we've reviewed it all.
Gotcha. Okay. Preliminary examination will be set June 23rd, 2026, 9 a.m. before me.
Thank you.
Bond continued as been. Court calls the case, People versus Stilton Gloucester.
Brian Bowling on behalf of Mr. Gloucester, Your Honor. Milton, can you state your name for the record, please?
Milton Gloucester.
Thank you. I have before me a plea form that indicates that the defendant will be pleading guilty to an added count 3 of operating while intoxicated, second offense, the maximum 1 year offense. Upon a successful plea that count 3, counts 1 and 2 would be dismissed. The defendant, and I'm going to check the boxes written here, but defendant has been approved for admission to the 15th District Court Sobriety Court. He is to complete the required observation on the 12th, tomorrow, June 12th, as well as any other steps required by the court. That's the court's full understanding of the agreement.
That is correct, Your Honor.
That's our understanding as well, Your Honor. And just for the record, the 15th District Court is requesting sentencing on June 18th at 8 a.m.
June 18th?
That's correct. So next Thursday.
Okay. Okay. This is really weird. I'll do that. May I have him sworn?
Raise your right hand. Do you solemnly swear in the firm the testimony you're about to give will be the truth, the whole truth, and nothing but the help of God?
I do.
State your name.
Middleton, Gloucester.
All right, sir, it is this court's understanding that you're going to plead to the charge of operating while intoxicated second offense. That's a misdemeanor punishable by up to 1 year incarceration, up to a $1,000 fine plus court costs. The court could also order community service and any rehabilitative programs the court deems necessary. The court could also order your vehicle forfeited or vehicle immobilized. The court could also order you to pay the cost of the prosecution as well as the cost of any emergency governmental service. You understand all of that, sir?
Yes, Your Honor.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge in this case. You understand that?
Yes, Your Honor.
And my understanding is that you'll be sentenced before Judge Moore in the 15th District Court, Sobriety Court. You understand that?
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now you understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
All right. You signed an advice of rights form, is that correct?
Your Honor.
Any question regarding any of those rights?
No, Your Honor.
All right. Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights of that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you're indeed guilty of this offense?
Definitely guilty, Your Honor.
November 14, 2025, at the location of Olive near and North Hamilton Street in the city of Ypsilanti, Washtenaw County, state of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, you consumed intoxicating liquor?
Yes.
You remember what you had and how much?
Yes, I do, Your Honor.
What'd you have and how much?
MXD.
All right.
My margarita.
Okay. Were you stopped by the police or was there an accident?
Stopped by the police.
Why'd they stop you?
They said that I was parked in the middle of the road.
You're not disputing the right of the police to stop you, are you?
No, I'm not.
Oh, okay. Were you ultimately arrested?
Yes, Your Honor.
Were you taken to the hospital for a blood test?
No. I was in.
Was there a breathalyzer or dating master or intoxilizer test?
Yes.
All right. And what were the results?
Your Honor, we would stipulate to a 0.108 and 0.114 on the intoxilizer for purposes.
114.
Okay. 108 and 114.
And sir, you have no reason to dispute those results.
No, I don't, Your Honor.
Had you previously been convicted of operating while intoxicated on or about July 23rd, 2007 in the 22nd Circuit Court, as well as operating while intoxicated and impaired by a controlled substance second offense on or about March 1st, 2010 in the 14A4 District Court?
Yes, Your
One
Honor.
of those you have? Okay. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea. Court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, I do.
All right. Counsel, you're aware of any other promises, threats, or other inducements which have led to this plea?
I'm not aware of any, Your Honor.
And have I complied with the court rule and would it be proper to accept this fitness plan?
Satisfied.
You have, and yes.
Court will accept the defendant's plea to count 3. Counts 1 and 2 are dismissed. It's going to pre-sentence evaluation and screening. Sentencing on this matter, you said June 8th.
That's what they're asking for at the 15th, Judge, yes.
June 18th, 2026. Do they give you a time?
8 a.m.
Wow, really?
Yeah, bright and early.
8? See, I told you guys you could be in here earlier. 8 a.m. Well,
It's got the observation.
Bond Wilkins. Yes, it's going to be there. Now I have my. I'm presuming I'm although this is Judge Barr's case. I assume I'm the transferring judge.
I believe so, Judge. Because you accepted the plea, then
I accepted the
proper for you.
Yeah, so I'll just do it if they want me to.
And then obviously, if they want
then.
me to get Judge Barr's signature, I'll do that.
Pardon?
If they want me to get Judge Barr's signature, I'll get that too, but.
Yeah, I mean, but I think, yeah, that'll work. All right.
Perfect.
Good luck, sir.
Thank you.
Court does call the case, people versus. Already call him Giovanni Pryor. Yeah, we did. Get a chance to talk to him?
Sir, I apologize. Appreciate it.
Stephanie Cannon on behalf of Mr. Pryor, Your Honor. And Mr. Pryor is asking for his preliminary exam. He thought today was the exam, Your Honor. I've explained.
Oh.
What
How
was
that,
happening.
right, okay. Preliminary examination, June 23rd, 2026, 9 a.m. before Judge Fresh Hour. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case, people versus Diagreer.
Morning, Your Honor. Reading for the people.
And Assistant Public Defender Nicholas Buckovich on behalf of Ms. Greer, who is appearing via Zoom. Ms. Greer, can you please state your name for the record?
Zaya Greer.
Hello.
Hello.
All right, what are we doing?
At this time, Your Honor, I'll be requesting I need to provide some mitigating evidence over to the prosecution for consideration of an offer.
Probable cause conference will be adjourned then to July 9th, 2026, 9 a.m. Bond continue.
Thank you.
Thank you.
Honor.
Court calls case, people versus Frank Hamilton.
Public Defender Natalie on behalf of Mr. Hamilton.
Oh, there you
Your name for the record, sir?
Frank Hamilton.
Thank you, Your Honor. I do have a green sheet here. Mr. Hamilton did provide me with some updated contact information just today. I have been unable to speak to him since the first when he was released from Wayne County. We're likely to speak tomorrow, so I'm asking for just a 2-ish week adjournment.
go. Probable cause conference, July 2nd, 2026, 9 a.m. Bond continue. All right.
Thank you.
Yeah, this is Mr. Heaton.
Yes.
Court recalls case, people versus Justin Heaton.
Pretty girl with the Your Honor.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Heaton, Your Honor. He's approaching the podium. You can state your name for the record, Mr. Heaton.
Justin Heaton.
All right.
Your Honor, may we approach briefly?
You may.
Thank you.
9 AM. And Mr. Getty, you wanted to argue bond on behalf of your client.
Yes, Your Honor. Thank you. Mr. Heaton comes before the court. He is here on a felony. He's got 2 counts there, both a maximum 2-year felonies. He has a couple other matters that are pending in the district courts, both in Saline and Chelsea. To the extent that he's not being held on those matters, so I believe they're both 30 and maybe a 90-day misdemeanor. He does report that he does live locally. The information I have in the file is that he does reside in Chelsea. I don't think he's a flight risk in any way to leave the jurisdiction where he released in this matter. I have discussed with him. He indicates that he would appear at any court hearing. And I have reached out to other people involved in ancillary matters, but I haven't heard back yet. So I'd ask the court to consider a personal recognizance bond in this matter so that he can return home to his home locally here, and it would be easier for him to deal with the pending legal matter.
Any response from the people?
It's understanding that their sheets are basically one city which their home and possibly that he straight by he as a fault and we would be flexible at those things.
What I'll do is this. I'm going to deny the request, Mr. However, I will reconsider his release if he's assessed by CMH while he's in the jail. And so I'll reconsider it. I wouldn't hold entirely his release based upon what might be occurring in the civil matter for his home, but just in terms, I need a CMH assessment and then I'll consider it.
Thank you, Your Honor.
All right.
Your Honor, may I ask the court if we were able to gather the information regarding the ancillary matters and submit perhaps a stipulated order to the court where the court could review it?
Oh, absolutely.
Thank you.
I would review it, see what we can come up with.
All right.
All right.
Thank you, Judge.
Thank you. Court calls case People versus Jerry Jackson.
People, Your Honor.
Hello, sir. What's your name?
Sorry, Judge.
It's okay. I figured he had an attorney, but he was going to handle it himself. I think he said something like, I don't need that. I don't need them. I don't know what he
meaning other things. Brian Bowling on behalf of Mr. Jackson. We're here for a PCC today. I'm asking for an adjournment. I gave Mr. Jackson all of his discovery materials this morning and just little time to review them, please.
All right. I'll adjourn it to July 9th, 2026, 9 a.m. All right. Thanks.
Thank you. Thanks, Judge.
Policy cases of the People versus Robin Nobles.
How's your day going, Your Honor?
I have to ask you that. My day's fine.
I'm having a great day.
Okay. All right. You have a client?
We are not sure where she is. She was released last night due to a high-risk pregnancy. She could be in the hospital.
Oh, yeah. Yes. Come on, you come on up too. Come on.
I don't do it.
No, stay out of his way. I'm just gonna learn to relax. So she
some very good conversations with my client regarding these two matters, and I have been able to talk about this with Mr. Cook. Mr. Cook did offer in this case. I am ultimately asking for insurance. I did discuss with Mr. Cook to provide some potential mitigation Cook and see if we can get a different offer. Mr. Cook said he would be happy to review anything I sent him. Of course, he can't guarantee if that offer is going to change at all or anything like that. But my client is requesting that I ask for an adjournment so that I can get that over. So I think 3-ish weeks would be enough time for me to.
How much?
3-ish. I would also accept 2 or 4 or whatever the.
That's why I missed me. Yeah, I'm not going to pick 3 weeks. I'm not going to pick 4 weeks. I need you to do a 3-ish. Will July 2nd work for you?
That would work wonderfully.
All right. July 2nd, 2026, 9 a.m.
Thank you, Your Honor.
Thank you very much.
On continue.
Thank you.
By what? Why are you yelling at me? Oh, I don't want to know. Where calls the case of the people versus Tegan Donnell? Yeah.
And Assistant Public Defender Natalie Pate for Miss Donnell.
Tell me.
Oh, I'm sorry to hear that. Is she not feeling well?
Since I saw her yesterday, yeah, I don't know how she's doing today.
Understood, Your Honor. So I do know she was in front of Your Honor yesterday, and I did then myself was able to go meet with her.
Do anything, otherwise she'd be, wasn't me. Don't try to blame me for that.
Oh, no, certainly not your fault, Your Honor. Nothing bad to say about you at all when we met. So that being said, I did meet with Miss Donnell yesterday at the Washtenaw County Jail, which that is, for the record, where she still remains. I was able to go over this case with her. I do understand that on her violation of probation matter, that there was a potential release to treatment, was my understanding.
That's correct.
I was going to be requesting today both an adjournment as well as a release to treatment on this file. I did mention that to Mr. Cook. I do not believe he has an objection. And if Your Honor was willing to grant that, I could submit an order today.
In order to that effect, that's not an issue. What date did we set her for yesterday?
I need to look at you.
Council approach, please. Yes, ma'am. Entered on the finding an order regarding competency originally. I did reach out to the Michigan Department of Health and Human Services yesterday by email asking if they had any idea when he may be placed. I did get a response to that yesterday afternoon that I shared with Mr. Cook. They were estimating an additional 4 weeks potentially before he's into a treatment facility, correct? Why don't I do what I did with the other one, so we'll check the status, but don't lose it. Just adjourn this to July 30th. And we'll see kind of where. Wonderful. July 30th, 2026, 9 a.m. for review. Yeah. And I didn't submit a green sheet. I didn't know if you know, but in this case, okay. Thank you. We'll continue. Thank you. Ready? Okay, fine. Gallon. You hear a tone in her voice? Where calls the case, people
versus Jason Brooks.
Assistant Public Defender Zach Vinny with and on behalf of Mr. Brooks, who is present via Zoom. Sir, Mr. Brooks, can you please unmute and state your name for the record? Mr. Brooks, are you there?
Yeah, that was loading. Jason Brooks.
Thank you, sir.
Your Honor, we would set for preliminary exam in this.
Going to set for a prelim. Discovery is complete.
To our knowledge.
People have their witnesses available the 23rd. All right. Preliminary examination will be set June 23rd, 2026, 9 a.m. That's before.
What you have to do is you have to go give our main clerk isn't here today, but you can ask for Danielle and just give that to Danielle. Danielle, what? Oh, I guess give it to Amy. All right. So she should be right out there at the last window. And then I will take a little look at that. Okay. There you go. We will go on the record in the matter 26 CF 22, State of Wisconsin versus Jesse James. The state appears through District Attorney Kevin Schmidt in person. Joel Feliski, Defense Counsel, appears in person. We do not have Mr. James. We were set today in this matter for a status conference. We had a waiver of preliminary hearing on April 13th, in which the court set this date and time, 9:15. It is now 9:22 and no appearance by Mr. James. Mr. Feliski, there's good weather and driving conditions. Is there anything that I should know?
Your Honor, I stand mute.
Okay. Mr. Schmidt, what are you requesting?
I'd ask for a warrant.
Okay, the court will issue a warrant. He was on a cash bond. The court graciously amended the cash bond because he told the court he would come to court, and he has now failed to come to court. So the court will issue another cash bond, $500. Only judge may quash or posting of the cash. He will be provided a new date and time upon posting. We are adjourned. Mr. Benson. I know it's not 9:30 yet, but I know that you are in a tight little time slot. So who do we have first, Mr.
Joel Nelson? Joel, I think your client's in the Pope jail on a probation hold.
Letting you know.
And Ms. Nelson would be entering a plea today, Your Honor. And that offer is still on the table from January.
Yes.
We will go on the record in the matters 26 TR 24, 25, and 26. State of Wisconsin versus Riley Nelson. The state appears through District Attorney Kevin Schmidt in person. Ms. Nelson appears in person with counsel Adam Benson. We're set today in this matter for a status conference. However, I've been informed that Ms. Nelson will be making a plea here today. Is that correct, Mr. Benson?
It is, Your Honor.
What is the agreement that's unreached?
She will enter a plea of no contest to the OWI first, 26 TR 26. We are going to amend the BAC to 0.099, $936.50 forfeiture, 6-month driver's license revocation. It hasn't been suspended yet, so it would not be retroactive. No ignition interlock device, dismiss and read in the other 2 citations.
Okay, can you give me a little bit of facts behind this OWI, just so I have a basis as to why she would be pleading no contest?
She can plead guilty, Your Honor. There's no difference.
Okay. I was just wondering if there was something that
No, not at all.
It's just a ticket, so I don't get information. All right, and that's the agreement you've reached, Ms. Nelson? Yes. Okay, so you've had plenty of time to go over this with your attorney? Yes. And he's went over your constitutional rights with you? Yes. And you understand that the state would have to prove by clear, convincing, and satisfactory evidence that you operated a motor vehicle while on a highway of this county and state, and that you were under the influence while operating that vehicle?
Yes.
And you understand the penalties that have been recited on the record here today?
Yes.
Formal motion to amend the BAC down to 0.099.
So made.
Granted. How do you wish to plead?
Guilty.
All right, thank you. The court will find you guilty of 26 TR 26, the OWI. The court will assess $936.50, no ignition interlock device, 6-month revocation of your driver's license. You don't get it credit. Your driver's license has not been suspended. So how are you able to get this paid? Are you able to pay it all off in one lump sum?
Yeah, I can pay it today.
Excellent. Thank you so much. All right. So if you want to go and make that payment, and then you are good to go.
Thank you.
All right. Thank you. Mr. Beestrom?
He's not here today, Your Honor. It's
Oh.
traffic though, so.
Okay. What? Okay. Because it's an OWI. Yeah. Sorry, forgot. Sorry.
I'd be asking for just one more status that will probably turn into a plea, Your Honor.
Okay, that's fine. We just got to wait a bit. I forget that usually Amy does the clerks for the OWI things, and so they're a little bit different than the criminal things. So we'll just have to wait just a second.
I just noticed something with our guidelines. There's one BAC that does not have a guideline.
Which one?
0.099.
Really? On the district?
The lowest guideline is below 0.099. And then the next one is 0.10 or higher. So exactly 0.099 has no guideline.
When's the last time the district put out, because I always Google it. What's that?
2024.
2024.
Yeah, we
Okay.
have not updated them yet. I think they are on our schedule. I think at our next fall.
Feel free to point that one out.
I will, and I will say, our district attorney noticed. I'll even highlight it right now. Are you ready or no? Okay, we'll go on the record in the matter 26 TR 21, 26 TR 20, 26 TR 22, State of Wisconsin versus Michael Bistrom. The state appears through District Attorney Kevin Schmidt in person. Mr. Bistrom doesn't appear, but appears through counsel Adam Benson, who is in person. We're set today for a status. Mr. Benson, please update the court.
Thank you, Your Honor. There is an offer. My client is not ready to plead yet, but I think we would be in 30 days.
Excellent. Okay. Can I please put this on an ADA week? It's just an OWI one.
Yes. It's just a status, right?
A plea.
Well, if you please, it's going to be OWI.
I've heard of it one, it's fine.
Okay. On July 7th, can you do 10:15?
I currently have a hearing in
1 o'clock.
Washburn. 1 o'clock I could do, yes.
All right, July 7th at 1. We will see you then. Thank you.
Thank you. You guys have a good day.
You too.
For Tess Anderson.
Company called Bayside Recycling.
Excellent, because I think that you either lost a job or quit your job, and then I know you were looking for another job. How do you like it?
I like it. It's going good.
That's really good to hear. I'm really, really glad to hear all of that, Mr. Lightfeather. We will go on the record in the matter 25 CT 33, 25 TR 492, 25 TR 493, State of Wisconsin versus James Lightfeather. The state appears through District Attorney Kevin Schmidt in person. We have Nicholas White. He appears by video conferencing, Mr. Lightfeather. The state appears in person. Nicholas White, defense counsel, appears in person. We're set today in this matter for a status conference. Mr. White, can you please update the court?
Thanks, Judge. Mr. Lightfeather has recently started a new job. He's been able to put some money towards treatment and begin an AODA in Siren. However, he does not have the money to prepay for the initial IDIP program, the prepayment of $375. He's saving up for that. I believe he has all the IDIP information. He has the contact information for Tess Anderson. He just needs some time to make that payment and then begin the program.
Excellent. Okay, sounds good. When do you think you're going to be able to get that paid?
I should have all the money for, I think altogether it comes up to like $950, but I should have that all by Friday.
Excellent. That's great because this is getting a little bit old.
Yes, ma'am, I understand. Sorry.
You're doing what you need to do. And Mr. Lightfeather, I mean, quite honestly, this is the best I've ever seen you. So I'm super proud.
Thank you.
So let's get a status date, maybe a month down the road, just to make sure that everything's been paid and we're all up to date and we're starting things. Let's see. Mr. White, can you do July 9th in the morning?
Let's see, Your Honor, I'm in St. Croix at 9 o'clock in person. I could do something maybe after 10 o'clock if it was by Zoom.
After 10:15?
That should work.
Or I can double you up. I do have another attorney with, I have 4 other cases at 10:30, but if you could do 10:15?
I don't expect it to last so long in then St. Croix, so 10:15 would work.
Okay, 10:15 by Zoom. We will see you 10:15 by Zoom on July 9th, okay?
Sounds good.
Sorry, July 9th. All right, thank you.
Yep, thank you.
Have a good day.
You as well.
Aubrielle, come on up.
No, it's okay. I just came in.
We will go on the record in the matters 25 TR 946, 26 CM 31, State of Wisconsin versus Aubrielle Succo. The state appears through District Attorney Kevin Schmidt in person. Ms. Succo appears in person with counsel Nicholas White. We're set here today in these matters for status conferences. Mr. White, please update the court.
Thanks, Your Honor. This is a case that before I was appointed, there was an offer extended from the DA's office having to do with the diversion program. My understanding is that's still the current offer. Aubrielle has basically had an issue just coming up with the funds to complete that program. For the last couple of months, it's what I would just call cost prohibitive. She has asked if there is a way that the diversion fee of $200 could be waived. My understanding from the DA's office is that it cannot be waived. I don't know if Your Honor ever has a say in anything like that.
You do not.
Okay, then that was my understanding from what the prosecutor said. I just wanted to bring it up either way. We are working on negotiating this case. I'd ask for a plea or status out a couple, maybe out a month. I'm not sure how long the diversion program would take. I know that my client started it. I don't know if she'd have to start at the beginning though, and then there's the fee itself. So that's where we're at.
How about, well, that's only 1 month out. get something a little later. August 3rd at 2.
That won't work for me. Looks like I'm in Barron County.
August 5th at 9:30.
I am in St. Croix at that time. I'd have the rest of the day after maybe 11.
August 5th at 3 or at 2:45.
It's Wednesday afternoon. To here. Doesn't try to schedule later for that.
I just don't know if it works for her because she has to drive me.
Okay.
Is there anything available for Thursdays at all?
I could do Thursday, July 23rd at 10:30 or at 10:30. Yes, 10:30.
I'm in St. Croix at 9:30. That's a status or a
How about
block schedule.
2:15?
I can make that work.
All right, July 23rd, 2:15. Potential police list evidence play. All right, thank you. You can come get your notice and you're free to leave. So Ms. Sukow, you have Thursdays off?
Yes.
Okay, so I will try to remember that if we need it for the future. We will go on the record in the matter 26 CM 36, State of Wisconsin versus Jaden Johnson. The state appears through District Attorney Kevin Schmidt in person. And we have Mr. Johnson in person without counsel. We're set for a status. Are we in victims' rights compliance?
Per status, yes.
And we can proceed at this time. It is 4 minutes early.
Oh,
Do we know if victims?
I don't know. I'm sorry. We should wait 4 minutes.
First off, though, were you going to talk to the district attorney? Because I think you were trying to do this yourself before you see if you need an attorney.
Yes, I wanted to complete the anger management, but I was unable to the past month or so.
You're just saying you need more time to do that?
Yes.
Okay. All right. So what I'm going to do is we will briefly adjourn so I can wait 3 minutes and I'll give you a new date.
Okay.
Okay.
All right. Thank you.
On the record, same appearances as previously noted. We are in victims' rights compliance. No victims have appeared. August 5th at 9:30. That gives you plenty of time to contact Mr. Hatch. I do it right away. And it gives you plenty of time to contact him, to pay the $150 and to get your sessions done.
Okay.
Okay?
Yep.
All
All
right.
right, thank you.
August 5th, 9:30, come get your notice and you are free to leave. Adjourn. We will go on the record in the matter 25 CF 96, State of Wisconsin versus Cody Erickson. The state appears through District Attorney Kevin Schmidt in person. Mr. Erickson appears in person without counsel. We are here today on a motion for an entry of judgment. Mr. Erickson pled guilty to 2 counts of battery, domestic abuse, 1 count of child abuse, intentionally cause harm, and an OWI second. He was placed on a deferred judgment of conviction agreement in which the physical abuse of a child in count 3 in the criminal complaint was deferred upon certain conditions, et cetera, being met. There are allegations that he has failed to comply. And the actual allegation is that the defendant has failed to comply by failing to pay the administration fee. Mr. Erickson, that is $150. Do you understand what it means why you're here today?
Yeah.
And so they're asking the court to enter judgment and to sentence you on that H felony, that very high felony, because you haven't paid $150.
I was wondering if I get a little bit more time.
How long would you need?
Probably not like a month, not even.
Mr. Schmidt, would the state be willing to stay this and adjourn it for another month to allow Mr. Erickson to be able to pay the $150 fee?
Yes. I've been looking for a job.
Okay, so what you need to do, it's very important that you figure it out. Like if people need help cutting wood and they'll pay you, $50, or if somebody will pay you $25 to mow their lawn, it's super very important that you figure out how to get this $150, okay?
Okay.
Because you do not want that judgment entered because you could be sentenced on that H felony. So that is a maximum of a $10,000 fine or 6 years of incarceration, prison. So it's very, very important you figure out how that you can get that $150, okay?
Okay.
Once you get that money, then you must bring it over to his office right there, the district attorney's office, the opposite end of this hallway where the court is, okay? On the right side. So as soon as you can get that done, the better, all right?
All right. I
will give you some time to be able to do that. I'll give you until July 23rd at 10:30. July 23rd at 10:30, I'm going to set this for another hearing. If you pay that $150, let's say you figure it out, you mow the lawns, you do the things, and you get $150 in 3 weeks. As soon as you get it, go and pay that to his office, and then you will not need to come back for that hearing.
Okay.
Okay? And grandma's here, so grandma understands everything that I said too, and she'll make sure that that all gets done, okay?
Okay.
Okay, you can come up and get your notice, but again, you do not have to appear if you pay the state. All right, thank you.
Can you hear me? You hear me, Your Honor?
I sure can. Let me make sure I can turn you up just a bit so my court reporter, we can make sure that she can hear you. Can you just say hello to Mr. Schmidt, the state?
Hello, Mr. Schmidt, if you're there.
All right. So, and everything sounds like it's all coming through clearly. All right. We will go on the record in the matter 23 CF 156, State of Wisconsin versus Daryl Hansen. The state appears through District Attorney Kevin Schmidt in person. We have Frederick Bechtold, counsel for Mr. Hansen, appearing by video conferencing with approval of the court. Mr. Hansen is waived of appearance here today. We are set today in this matter for a status hearing. And I don't know if that's quite the way to describe this hearing. It's more than just a status, I believe. I think there's a couple things that we do need to address. We did have Attorney Bechtold did file defendant's motion for post-conviction relief. The court has thoroughly reviewed that motion, as well as all transcripts and all necessary information related to that motion. The court has also reviewed the state's memorandum of law and recommendation for scheduling. We are essentially here to schedule. We are here for a status. We are here for, quite honestly, a bunch of things. There is a statement made by Attorney Bechtold in which he believes that his client, who has been sentenced to prison for his guilt of plea to counts 1 through 6, first degree recklessly endangering safety, class F felonies. Mr. Attorney Bechtold is petitioning the court or making the statement to the court that he believes at this time his client is not competent, and therefore we need to proceed in that manner. Mr. Bechtold, is what would you like the court to be aware of? What do you want to accomplish for today's hearing?
Thank you, Your Honor. And by the way, it's a pleasure to appear again in the Burnett County Circuit Court. Wish I could have done the drive up there. Probably wouldn't have been an efficient use of time, but that is a very pretty drive up there from Taylor's Falls to Siren, and I always enjoy it. Yeah, I read this state's reply or response to the motion. I'm guessing I wasn't entirely clear in my motion. I thought I was, but I want to make it just clarify some matters. I am not suggesting that we can proceed at this time to the more substantive claims I made. If you look at 37, I even say those are contingent claims. We have to first establish competency to assist in the post-conviction. If he's not competent to assist for post-conviction, then we cannot proceed to those claims, and we have to either wait till he is has competency restored, or if it's permanent. I'll be honest, I'm not entirely sure what happens in that situation, but we can address it at that time. I would more clearly say I have reason to doubt his competency. I'm not making a statement one way or the other about competency. My experience over the years dealing with competency issues and in criminal and guardianship cases is that I can get faked out. It's very, very difficult. Sometimes I think people are not competent, and they are. When the actual experts get there and look at them, and other times they are not. the other thing is that I did not mean to suggest by requesting an independent expert that person would take the place of the forensic unit. Obviously, the forensic unit will examine them. That I will admit, I wasn't entirely clear in the motion. I did prepare a proposed order, actually, for the forensic unit to go ahead and examine him. And by the way, I think it's in the motion, but I would repeat for he's in the Wisconsin Resource Center right now, so they would probably be right close to actually examine him. The statute, 914, I forget the exact subparagraph, does provide that I can get an independent expert to examine for the competency hearing. And maybe down the road, I'm going to need that expert for my more substantive claims. That is why I've requested the ability to appoint my proposed expert. Dr. Endress is very qualified to do this kind of thing. She's in Appleton. Her rates are typical of this kind of thing. And I'm hoping the court will allow me, because I want to get things moving along. I don't want to wait till we get a report from the forensic unit and then I say, well, Your Honor, I'm going to contest competency, and then I have to get an expert. Why not have her go up there and examine them right away? So I have reason to doubt. It's not simply the matters in the record. There are some other things that have occurred since that, just cause me to have doubts. And basically the nature of my claims kind of requires me to go ahead and have them examined anyways. So I'm thinking that the best way for us to move forward at this time is that I submit an order to the court for the forensic unit to examine them. I have another order to allow the appointment of Dr. Endress, and let's get them examined. And I don't know, honestly, maybe the state has more recent experience. I don't recall how long it would take to actually get these reports, done. But I would think we should schedule out a little bit for a competency hearing. I don't know if 45, 60 days. I don't know what, I really don't have a thought on that.
The last one we did where they're in custody, it came back in actually like 2 weeks.
Yeah, it could be very quick. Mr. Bechtold, first, I want to say that I completely understand you weren't suggesting that we proceed with your post-conviction claims prior to raising competency. That was clear to this court. And it's good to hear your reason to doubt his competency and your explanation for that. And I also do understand that you weren't saying let's totally bypass the Wisconsin forensic unit, but I do also understand that you would like to have your own independent expert to be retained, and it sounds like you would like them to be retained sooner rather than later. For the record, and so you can be aware, I'm aware of Dr. Endress. I respect her as a professional, and I think she does a very thorough job. Before I make any ruling or I state what we're doing, Mr. Schmidt, what would you like the court to be aware of or on the record?
My main goal with my thing is I saw the court was scheduling it for a scheduling conference. That's why I titled it the way I did. And I stayed away from any substantive claims because I read the defense motion. It's very, very long, and it kind of mixed at certain points the substantive claim with the raising competency now. So I filed it just as like a protective measure because I wasn't sure exactly what they were asking for. So it sounds like we're actually all on the same page.
And we are. And just so you can be aware, Mr. Bechtold, what Mr. Schmidt stated is accurate and true, that sometimes we get the reports within 2 weeks. It's a very quick, especially when they're in custody. Sometimes it could be 45 to 60 days. When an individual is out of custody and they're unable to try and connect or whatever with the person who is performing the evaluation, that sometimes has been a little bit longer. And then we need to make sure that we can detain them or make sure that there is something where they can meet. Here we have Mr. Hansen, who is very close, as you said, and he's in the Wisconsin Resource Center, so he's very close to the forensic unit. So they should be able to get something done relatively quickly. So with that, the court is going to order that a competency evaluation be completed by the Wisconsin Forensic Unit. You don't have to worry about that order. My assistant prepares that order for my review, and I do sign it right away, and it gets done very quickly. At this time, I am denying your request to get an independent examiner evaluation at this time. I believe that right now with the cost of the Wisconsin Forensic Examiner, and we don't know what the outcome's going to be, and it could be relatively soon. At that time, you can re-raise your motion for your independent medical examiner or evaluation, and we can get that in the process if that is a need or a request at that time. So we will get this competency evaluation ordered, and hopefully they can get it done really quickly since they are in a very good location. And then you will get the report, I will get the report, Mr. Schmidt will get the report, and then we can go from there. And if after reading the report, you do believe it is necessary for your independent examiner, then you can file your motion, and hopefully it'll be all within a good amount of time. What I can do is schedule a status conference, perhaps 30 days from now, to see if we have the report, we have everything, and then we can go from there. Does that sound reasonable?
That sounds very reasonable, Your Honor. My reason for requesting I just wanted to be very upfront about where I think we're headed. Obviously, the substantive motions, if he is found competent, Mr. Hansen's going to have to tell me, yeah, do that. You know, I don't want to get into communications, but I will definitely, if his competency is established in the future, I will get him to reaffirm or something like that I go forward on that. As far as now versus I was just trying to be proactive, and but I think what you are suggesting is entirely fair.
All right, thank you, Ms. Bechtold. And I understood where you were coming from and why you are using the blocks the way you are. Does July 13th at 10:45 work?
Yes. Should I appear in person for that, Your Honor? Or do you want to do that by Zoom?
We can do that by Zoom. Right now, I'm going to label it as a status. If we get the competency report by then, we'll be able to know where we're going and what you're going to be requesting and where we need to schedule for later. Hopefully, we will definitely have that report by then. Anything else that you can think of for today, Mr. Bechtold?
Shall we have Mr. Hansen appear by Zoom?
That's your call, because quite honestly, it may just be a date like today, where we're just going to say, okay, the report says he's competent, or the report says he's not competent. This is what we need to do and where we need to go next. That's your call. And if you think that it would be beneficial for him to make an appearance.
Well, as I recall maybe it would be best that we schedule a competency hearing at that time. As I recall, I
don't have time for a full-blown competency hearing at that time, unfortunately. I wouldn't have time for a full-blown we may not even need one.
Yeah. Is there not a requirement that the court inquire of Mr. Hansen whether he feels he is competent, and then depending on his answer, we schedule a full-blown hearing?
We can have him appear, and that would be totally fine. And then we can schedule the full-blown competency hearing. So we can get it arranged, or you can contact the Wisconsin Resource Center to get it arranged so we can have him appear. That's no problem. I'm sure that's going to be a lot easier than if we're going to go to Dodge or something.
Yeah. Your Honor, I believe that your office will have to contact the Wisconsin Resource Center. They will not. I can provide your assistant with the contact, the scheduler, but she may have that already.
I don't know if she does. So if you want to email Mary and give her all that information, that would be great.
I'll give her the entire sheet for all the facilities.
Okay, thank you. I believe we are adjourned.
What time was that, Your Honor, by the way?
10:45, July 13th.
Okay. Thank you, Your Honor.
Thank you. For the record.
Fully signed.
I believe the clerks usually make one.
Okay.
We will go on the record in the matter 25 CF 146. State of Wisconsin versus Riley Jones. This date appears through District Attorney Kevin Schmidt in person. We have Michelle Erdman, Defense Counsel in person, along with Mr. Jones. We're set for a plea and sentencing. The parties have reached an agreement. Ms. Erdman, can you please recite the agreement for the record?
Judge, Mr. Jones is going to be pleading guilty to the count of possession of methamphetamine as a felony. And we're asking the court today to consider deferring entering judgment on that for a period of 12 months. Upon successful completion of the 12 months and all of the conditions, he would be receiving an amendment down to amphetamine possession for court costs would be the joint recommendation.
Okay. Just need to make sure. I know you have cash filed for bail, but I'm not sure how much. The clerk will have to check on that because you used to have 2 cases and then it went away and then that was all combined. Are you dirty?
Am I dirty?
Working?
Yeah, I was working a little. I tried to clean up the best I could. Sorry about that.
Totally fine. I just looked at you and I'm like, your skin looks
Yeah,
great.
and my hands are all dirty. And
Makes
yeah,
sense.
sorry about that. I tried to clean up the best I could with
But
the
you
garden
look
hose.
dressed appropriate, so
Yeah.
that's fine. That's fine. I just wasn't sure if I was.
Yeah.
Okay, so the clerk will check on that because I want to make sure that you have the ability to have the $150 to go to the state and to keep the amount that would be for court costs and fees if this is amended, okay?
Yeah.
So, okay, how much do we have? $1,250?
Because oh, sorry. I got that one bail jumping charge, and I think my mom filed a motion to get that money back because it was dropped or something, and it wasn't gonna get. Or you said it that you couldn't. Yeah.
She will get some back, but then some will still be held for later.
Court
Okay.
costs and stuff.
If it is $1,250. Okay, so you've heard the agreement that's been reached, correct?
Yep.
And that's the agreement that you agreed to with the state?
Yep.
And so I have in front of me a plea questionnaire waiver of rights form. Do you recognize the documents?
Yep.
Can you say yes?
Yes.
Sorry, it's just easier
Yeah.
for the court reporter. And so your attorney went over both of these documents with you thoroughly?
Yes, ma'am.
Essentially, did she go over them word for word?
Yep.
And you understand them completely?
Yes.
Did you sign both of these documents?
Yes.
So you're pleading guilty to 1 count of possession of methamphetamine and I felony. You're 22. You have your GED or equivalent. You understand and read, write the English language. No drugs, no alcohol, no medications, no mental illnesses or disorders, correct?
Well, he does have mental health, but he's not being treated for one at the moment.
Okay, so you're not currently being treated for mental
Yes.
health. And is that the ADHD, depression kind of thing?
Yeah.
Okay, but you're not taking any medication.
No, not right now.
So with what you've been diagnosed with, are you in a position today where you can fully understand and comprehend
Yes.
everything?
Yes.
Okay. Did your attorney thoroughly go over what the state would have to prove your guilt?
Yes.
Did your attorney go over with you the maximum possible penalties you face?
Yep.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on the first page of both of those documents. Did your attorney thoroughly go over those rights with you?
Yes.
Do you understand them completely?
Yes.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do I need to go into those rights, into any more detail with those rights with you?
No, thank you.
Okay. You understand them completely?
Yep.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yeah.
Do you understand that by pleading guilty, and if the court does enter judgment and you are convicted of methamphetamine, a felony, you would not be able to use or possess a firearm for life,
Yes.
and you wouldn't be able to vote in any election until your civil rights are restored?
Yes.
Now, did you go over the criminal complaint with your attorney, that original charging document where it says what happened and why you were charged with the crimes?
Yes, ma'am.
For the most part, are those facts accurate?
Yes.
Are you admitting here today you in fact did possess methamphetamine
Yes.
and you knew it was methamphetamine?
Yeah.
Ms. Birdman, may the court use the probable cause section of the criminal complaint with the statement and acknowledgement by your client to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you?
No, ma'am.
You're pleading guilty freely and intelligently, telling me you fully understand what you're doing
Yes.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
And she's answered all of your questions?
Yes, ma'am.
She's looked at this matter thoroughly.
Yes.
Has she looked at the evidence, the discovery, and discussed it with you? Did she go over, you could have
Yeah.
a defense here or not, or this or that?
Yeah.
So she went over everything with you.
I mean, what I had, yeah.
Yeah.
And you told her everything that you know to exist about this case in this matter with your attorney.
Yes.
And are you satisfied with her services?
Yes.
Do you understand that I don't have to follow this agreement?
Yep.
And the state would have to prove that you possessed a substance, the substance was a controlled substance, methamphetamine, and that you knew or believed that substance was a controlled substance, methamphetamine. Do you understand what they would have to prove?
Yeah.
And that maximum possible penalty could be a fine of up to $10,000 or 3.5 years of incarceration.
Yes.
And both parties are asking the court to accept a deferred judgment of conviction and to kind of hold it out there for a period of a year. Do you understand? I don't have to follow that.
Yes, I do.
And I could sentence you to the maximum penalty if I thought it was warranted.
Yes.
Do you still wish to proceed?
Yes.
Do you have any questions for the court or for your attorney before we proceed?
No.
Then as to count 1, possession of methamphetamine, and I, felony, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1, possession of methamphetamine. Count 2 will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Oh, no, take that back. Taking that back. I'm hearing about the deferred. Mr. Schmidt.
We'd ask the court to accept the deferred judgment conviction agreement. It's essentially the inverse of what we normally do, where we offer, if you get treatment first, then we'll do amphetamine for costs. This flips it by having them do treatment and earn the amphetamine for costs. So I think it's appropriate. Simple possession is not a crime of moral turpitude. It's a crime of substance abuse. Riley Jones already has a significant history of getting treatment for substance abuse. He was on the treatment court program for some time. This appears to be a momentary jump off of it, and that I think this is the best way to go about addressing it. Thank you.
All right, thank you. Ms. Erdman?
Thanks, Judge. So what we know about addicts is they do from time to time have lapses, and now Riley's got, yet another set of hoops to jump through or climb through in order to kind of get himself out of legal trouble. I guess one of the things that's notable is he's not a felon yet. So if he doesn't follow through with this agreement and the court does revoke the deferred agreement, he will then have that as a probably a lifetime consequence. And I know he wants to avoid that. So I think he is motivated to do the right thing. We were really careful about going through every condition so that he would understand, the importance of completing them timely. He did mark up the document that you have there, and I told him I'd get him a copy. So I think he's committed to this, Judge, and I do expect that he'll do fine. He's working right now, laboring and just working really hard, and I think that says a lot about someone at his age, and he's still obviously getting his frontal cortex developed. One of the things that he's a little concerned about, Judge, and I don't know if you have any ability to address this today, is that the bond conditions will remain in effect. And I think you may recall that he got into some trouble having I
wasn't even noticing, sorry.
Having a prior condition of no contact with people who are on probation, I think. And he was pretty upset that it's hard to sometimes unearth from people whether or not they're on probation, and felt like that was something that he may struggle with just because in day to day, it's hard to verify that. And so he's hoping the court would consider making that something that is going to be something he can comply with and not impossible, if you will.
All right, Mr. Jones, what would you like me to know?
I would just like to know, I struggled when I got out of drug court because it went from like, I had all this support and I had all this, like pretty much what you had said you were worried about with me. And I slipped, I did slip, but I seen how bad that like tore my mom up and my family up. And I was able to get back up on my feet and was able to use the tools I learned in the drug court program to, you know,
Just slow down just a little bit.
and use the tools I learned in drug court to kind of help me maintain being sober when I got out on bond and stuff. And I would just ask for you to go with the agreement because it would mean a lot to me to be able to continue to work and, you know, just continue my life as is right now because it's been going pretty good. That's all.
Well, I'm glad to hear that because I'm not gonna lie, I worry about you sometimes, Mr. Jones. And I sometimes worry about the people that you associate with.
Yeah.
Because I've seen you at your worst.
Yeah.
And I've seen you at your best. And I don't want to see you in orange. And you escaped a very lengthy jail sentence from your convictions when you were in treatment court because you had 1 year, 1 year, 1 year, all consecutive jail.
Yeah.
That would have been worse than prison.
Way worse.
And then you successfully completed treatment court. You were doing so well. And then you started hanging around the wrong people again.
Yeah. And I've pretty much completely cut myself off from all them people. I've been going to work, going home. That's about it, really.
And that's what I want to hear. I want you to be boring.
Yeah.
Okay. And no one more than your mother, though, wants you to be on the straight and narrow.
For sure.
She's been there with you on your way worst.
Yeah.
And on your way best.
Yeah.
And I have seen your mother's heart break more times than I probably can count.
Yeah. And that's what that last time was just when I fell off after drug court. It just, I don't want to do it to her again, you know, because she is a really good woman. She's like the best mother I've ever asked for. So I don't want to disappoint her again.
I mean, she raised you by herself.
By herself completely, me and my sister.
You know, and she did it all. She was there for you for everything. And she never turned her back on you when you were doing some pretty bad stuff when you were young.
Horrible things.
And to see where you've come from and to see where you are now, I mean, it really is great. And please, I know I can say I can do everything, but doesn't mean people will listen to me. Doesn't mean people will follow. I truly want to see you do better.
Yeah.
I don't want to see you using methamphetamine. I don't want to see you dealing methamphetamine or any other drugs. I don't want to see you hanging around the wrong people who are going to bring you down. They will bring you down.
Oh, yeah, I know.
So I'm going to accept this deferred judgment of conviction. I will amend your bail. You may not have contact with Bradley Belisle. You may not have contact with Kyle Roofstone. You may not have contact with Dominique Fleckner. But she's with Bradley Belisle.
Okay. Sometimes I do work with Kyle. So I like work for him.
You work for him?
Yeah, doing the septics and stuff sometimes.
Is it with Kyle or his dad?
Kyle.
Okay.
And
Well,
Kyle's been doing good. Like that's why they gave me the bail jumping charges because I was with Kyle, but Kyle hasn't had a charge in probably 10 years. I mean, he did get raided that one time, but
The fact that you don't have a charge doesn't mean that
Right,
you're not
I know.
engaged in criminal
Yeah,
activity.
but Kyle actually like strive, like he pushes me to do better and like actually like, you know.
Here's what I'm gonna
But
do.
I mean, that's completely up to you. I'm not saying you know.
I don't want to interfere with your work because I know his dad and his mom and, you know, all of the things in the community. But I'm going to say no contact with Kyle outside of work, at least right now, because I don't know. I haven't seen Kyle in a long, long time.
Yeah.
But the last time I saw him, it wasn't in great circumstance.
Right. I completely understand.
And I understand the difficulty in not knowing who's on felony extended supervision or probation, and you're not on probation. Generally, that's something that I use if I put you on probation, because your agent will know.
Right. It's just hard because some people lie about being on probation because they don't want other people to know they're on probation. They don't want, you know.
I understand. So that's what it'll be. I'm also going to include absolute sobriety, testing upon reasonable suspicion, arrest, or any court directive. Those are what I'll add, and I'll take away the others. I am going to order that with this deferred judgment of conviction, $150 from the bail money will be diverted and sent to the district attorney. That condition now you're relieved from, okay?
Okay, so that's paid?
That will be paid.
Okay.
I'm also going to order that $500 remain as bail in this case, because it would be used to pay court costs and fees if this is amended, or actually 525 is going to stay. I don't know if it's going to be a felony or if it's not going to be a felony. You know what I want though? It not to be a felony.
Right, yeah.
So $525, the rest will be remitted back to your mom within a week or two.
Okay.
Okay. I think that covers everything. I'm really glad to see that you're turning things back around. I can't stress again, I don't want to see you in orange, and I don't want to send you to prison.
Yeah. I don't want to go to prison.
I don't want that either. So anything I'm missing, Mr. Schmidt?
No.
Ms. Erdman?
I don't believe so, Judge.
All right. Yeah, that can stay. Yes. All right. Thank you. Then we are adjourned.
Thank you. Before you go get a copy of that, I think the clerk's office can help us, just so that you've got it and you can read it, right? But it's that AODA assessment done, and then notice of the completion. When you're done with it, you need to tell someone at the DA's office.
Just bring it up to the DA's office.
Yeah, just bring it up to the DA's office.
Mr. Chapman?
Then I need to have him sign.
I have appointed you to a case if you're willing to take it. He was here this morning. It's an OWI 3rd. I'm printing the complaint right now. I set him on a status date for your time in July. He's doing the IDIP, and he's like, I want to save money on attorneys. But he's doing the program and he's doing the things, but I said it's probably best to have an attorney to review all the things. So if there's not a conflict, if you can take that, that would be great.
Yep, looks fine.
Okay. Leon Chapman?
So I will mail you, the copies of these. Once you get out of court, so you just have to send, no, down where it says defendant signature in those boxes. Nope, up. The thumb's pretty close to it, that's right there. So I'll get you, I'll mail those copies to you.
will go on the record in the matter 26 CF 35, State of Wisconsin versus Leon Chapman. The state appears through District Attorney Kevin Schmidt in person. Mr. Chapman appears in person with his counsel, Daniel Chapman. We're set today for a status. Mr. Chapman, can you please update the court?
Your Honor, I have the discovery and I believe I had an offer too, but that was a while ago. The issue here is there's a prior conviction from North Dakota that I have been able to confirm that there was no attorney for, but beyond that, I'm going to need to request a transcript. There's also a possible stop issue that I discussed with Mr. Chapman today, but if I file that, I'll file it at the same time as the collateral attack motion. For now, I would just ask for another status hearing.
What year was the North Dakota?
One moment. 2011.
Okay. I don't know their retention statute or policy, but
We will see.
all right. And so how long do you think you're going to need?
If you give me 2 months, Judge, I'll know by then.
I can do either various times. I'm pretty open in the morning and a little open in the afternoon on August 3rd, or I have a few time slots on August 5th.
Looks like I'm already in front of you the afternoon of August 5th. Could we do it sometime then?
When are you in front? Oh, I just pulled you up at 2:15 to 2:45.
Also 1:45.
1:45 minutes plea and sentencing. And plea and sentencing. Why don't we do 1:45? We'll quick do the status and then we'll move on to the plea and sentencing
Thank you.
on August 5th. You can come get your notice and you are free to leave.
Is it 2:45? That's still your number?
1:45.
Oh, yeah, thanks.
Do I have
I'll be in touch before
Jonathan
then.
Lowry or Byron Benjamin? Or are we going to go right to Mr. Morales?
Lowry is here. I haven't even looked for Mr. Benjamin yet. He's not until 11:30, I thought. But isn't Mr. Morales at 11?
He is, yes.
Okay.
I was just wondering. And I did actually do a written decision, but I haven't filed it yet. So I have to make sure this is the right one. I finished it yesterday. So I just need to. Oh, there you go. Yes, yeah.
Don't see Mr. Benjamin yet.
Okay, Mr. Morales. In 1 second. Oh, shoot. Sorry, 1 second. Oops. We will go on the record in the matters 26 CM 32, 26 TR 04 and 19, State of Wisconsin versus Anthony Morales. The state appears through District Attorney Kevin Schmidt in person. Mr. Morales appears in person with his counsel, Daniel Chapman. We're set today in this matter for a status conference. We had a suppression hearing not too long ago. The court did take it under advisement, and I have now uploaded and signed my order, my suppression order. So I'll go over it very quickly with you, but it is in more detail in the decision. The court here's the thing. There were certain findings that the court did make. That on January 1st, 2026, during the daytime hours of New Year's Day, approximately 12:07 p.m., the arresting officer responded to a single vehicle accident. Upon arrival, the officer observed the defendant's vehicle resting on the roadside ditch, stuck in the snow. One of the tires was continuing to spin or rotate. No other vehicles were involved in the accident. Upon making contact, the defendant was a sole occupant of the vehicle. The officer stated and testified at the suppression hearing he observed multiple signs of intoxication, including a strong odor of intoxicant emitting from the defendant's breath, glassy and bloodshot eyes, and the officer testified that his speech was slurred or somewhat broken. In response to questioning from the officer, the defendant admitted to consuming alcohol and stated, well, it was New Year's. So he had alcohol. He did not want to perform the preliminary breath test. So the officer asked him to perform the standardized field sobriety tests. The defendant complied and he performed the test. We watched this on video. He passed all of the tests or showed only minimal signs of impairment except for the HGN, the horizontal gaze nystagmus test. The court does find, after watching the video and observing the officer perform that test, and with the exhibit provided by Attorney Chapman for the National Highway Traffic Safety Administration guidelines, the court does find by this viewing that the HGN test was not performed accurately or properly. The court did review the legal standard for probable cause for an OWI and the test of the totality of the circumstances. In reviewing this and the impact of the inaccurate or incorrectly applied HGN test, the defendant does argue because that test was improperly administered and because he did pass the other field sobriety test, the other indicators of impairment are legally negated. But however, Wisconsin law does explicitly reject this. The court did view the case State v. Felton in reviewing this, and there the Court of Appeals held that a driver's successful performance of roadside field sobriety test does not cancel out, erase, or subtract from other compelling independent evidence of intoxication known by the officer. The court cannot confirm whether or not there was bloodshot eyes or glossy eyes, or whether or not alcohol was emitted from the defendant's breath. That is an observation that the officer must make in the field while observing the defendant. The court did have the ability to review the field sobriety test, the standardized field sobriety test by the video, and the court does state that because of the failure to administer them properly, the HGN test does not come into play and is excluded from the assessment and the determination because it is a flawed test. So that so it cannot be used to support a finding of probable cause. However, in reviewing all of the other factors and all of the other cues that the officer did see with regards to this matter, the fact that this was a single vehicle crash into a ditch, the noon hour on New Year's Day, which is a holiday that is heavily associated with alcohol consumption. The weather was snowy, but it was not snowing at the time. It was bright and sunny. No snow was falling. However, the defendant was indicating that he did admit to drinking alcohol, and the officer did have a strong odor of alcohol, glassy eyes, slurred or broken speech. Therefore, based upon that, the court does find that a reasonable officer, considering all of these factors together, would still form a reasonable belief that defendant and his ability to operate a motor vehicle safely was impaired. While his performance on the physical test, even the court viewed him performing these tests, him doing this suggests that he may have a high physical tolerance or a high level of physical coordination. It doesn't override the substantial physical or other behavioral evidence of intoxication witnessed by the officer. Therefore, based upon those reasons, the court is denying the suppression motion. So we do need to figure out where we're going with this matter now, Mr. Chapman.
I'd ask for a status conference to give me time to discuss that with Mr. Morales.
How far out would you like?
I don't need 2 months. I'm in front of you on the 24th at 3. Yes.
Okay, if you want to come June 24th at 3, that's fine.
Yeah, I've got a plea and sentencing here at 2:15. So.
Oh, what? Let me just pull that up. June 24th.
Thomas Toll.
June 24th. At what time are you here?
Well, my calendar is actually a bit odd. It's the physical image on my calendar is marked at 3 o'clock, but the text in the entry says 2:15.
I don't have you on 2:15.
Well, maybe it got rescheduled.
So you said Toll?
Yeah, Towle.
Yeah, I know Mr. Toll.
Well, I could make an appearance at that time either way. If I'm not coming here for something else, I would appear by Zoom.
That is scheduled for August 5th at 1:45.
Yeah, it looks like I just forgot to take the old one off my calendar.
I can do your July 20th at 1, unless you want it earlier.
No, that's fine.
So July 20th at 1 p.m. We'll have a status. All right, you can come get your notice and you're free to leave.
I have
Mr. Benjamin?
at least one more case.
What?
And if you want to talk to me after I'm done, you can hang out out there.
Or
Otherwise, just give you a call
are you with Mr. Lowry?
hang out there. Okay. Lowry is here. I don't believe Benjamin
So we
is.
can do Lowry?
I'll go check the hallway and see if Benjamin's here.
Lowry is a CT.
Okay, I didn't even notice.
I don't see Mr. Benjamin anywhere.
Mr. Lowry? We will go on the record in the matter 26 CT18, State of Wisconsin versus Jonathan Lowry. The state appears through District Attorney Kevin Schmidt in person. Mr. Lowry appears in person with counsel Daniel Chapman. We're set for an initial appearance. Mr. Chapman, were you able to go over the criminal complaint with Mr. Lowry?
Yes, Your Honor. Mr. Lowry understands the charges and the possible penalties. We will waive reading of the complaint and plead not guilty to each of the 2 counts.
Not guilty plea will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. Is he looking at the IDIP program?
He's actually already completed the IDIP program.
Oh, I think you said you were doing that some time ago. Well, that's excellent and that's great. So what are we doing? You just need time to review and do
Yes, I need to get the evidence and review it, and assuming there are no issues with the actual evidence, we'll set a plea after that.
I don't know how soon you want to come back because I could schedule you for July 9th in the morning if that works.
Can we just use July 20th?
Let me go
Or
to
is
that
that
date.
full?
I know that I'm booking you pretty heavy on that date and time.
It's
but
just a
July-
status.
Um,
Otherwise, July 9th, I would be available in the afternoon, but I'm not here for anything else that I can see.
I can schedule you for July 20th at 1:30.
Thank you.
July 20th at 1:30, you can come get your notice and you're free to go.
I will get the evidence before then and give you a call.
Would you like to try and call Mr. Benjamin?
Yes, Your Honor.